Any adjournment request?
Item number 5 years. Next week, I have to file additional affidavit. I have prepared, but the petitioner is unable to come. Next week, any date.
On the request of Mr. S. Islam, learned counsel for the petitioner, please the case on so and so. First of, he has submitted that the additional affidavit, an additional affidavit will be filed in the meantime. First of, Mr. H.K. Hazari, the learned engineer, for the state respondent, then is present.
22nd May.
May I please, Lord, I beg to mention for listing of a matter on any date next week.
Motion,
Motion, no, my lord, for orders, it will be for orders, my lord.
orders.
And I is there,
I.
my lord. Obliged, my lord.
May I please, your lordship? Lordship, I beg to mention item number 4. Lordship, in this matter, some documents were sought for from the petitioner, but which is not yet received. Lordship, may I kindly grant 3 weeks' time?
Motion,
Yes, Lordship.
3 weeks, let us see.
Lordship.
No, we'll call
Yes,
the matter.
Lordship.
Day after will pass.
May it be please, your lordship. Lordship, I beg to mention item number 35, lordship. Matter may be adjourned for the day only, lordship.
35.
Yes, lordship.
Okay. On the prayer of Miss S.
S.A. Khalifa, on behalf of M.A. Sheikh, lordship.
Learned counsel appearing on behalf of Mr. M.A. Sheikh, learned counsel for the petition. How much time?
But day only, lordship. Just on day.
The case is passed over for a day. It is submitted that consent has been taken from the learned counsel for the
Interim is.
to make the prayer. Interim order, if any, it will continue till the next date of listing. File.
Please, your lordship, I beg to mention item number 11, my lord. May it be adjourned for 2 weeks.
Motion matter. Let
Motion.
us see.
My lord,
After filing, why 2 weeks?
initiate-
Let us see.
May it please, your lordship, I beg to mention item number 10, prayer for adjournment.
Item number 10.
10.
Yes. What kind of adjournment?
Due to some personal difficulty.
Okay.
Yes.
When do you want?
Any date may be given after 2 weeks.
On the request of Mr. Your name?
A Deka.
A. Dekal and counsel for the petition. Please the case on so and so.
May I please, your lordship? I need some accommodation in item number 46. Lordship, we want to withdraw the petition. The matter has
46.
become infructuous.
46. Okay, your name, please?
PJ Bora.
Mr. P.J. Bora, learned counsel for the petitioner has submitted that the subject matter of the petition has become infructuous. In such view of the matter, the petition can be, the petition is not fixed. First, Mr. G. Jalan, learned counsel for the respondent court is in attendance. First of, in view of the above submission made by Mr. Bora, learned counsel for the petitioner, the petition is dismissed, the petition having been rendered infructuous, is dismissed. Has not fixed.
Daily list for motion. Item 1.
Heard Mr. A. Concord, learned counsel for the petitioner. This contempt petition is preferred, alleging non-compliance of a direction made in an order dated 1/4/2026. Passed in a petition WBC number 1882/2026. It is averred that the order dated so and so was duly brought to the notice of the respondents. Post of para. The repetition WBC number so and so was preferred, stating that the savings bank account of the petitioner maintained at Ujan Bazar branch. Savings bank account number, page 11, maintained at Ujan Bazar branch of ICICI Bank Limited was kept frozen for more than 1.5 hour, 1.5 years. Close to. The petition was disposed of with a direction to the respondents to defreeze the said savings bank account and to allow the petitioner to operate by keeping a lien over an amount of rupees 10,600.26. Full stop. In this contemplation, it is alleged that despite the direction, the savings bank account of the petition has not been allowed. The petition has not been allowed to operate the savings bank account. So we should notice returnable on steps upon the respondents. By speed post into working this.
17.6. Item 2.
May it please your lordship. My lord, this is a contempt application, my lord. The order is at page 13.
Heard Mr. K. Mohammed and a counsel for the petition. So this contempt petition is deferred, alleging non-compliance of the direction made in an order dated 24/6/2025.
My lord.
Passed in a petition application number 1013/2025. Post of is ever that the order dated so and so was duly brought to the notice of the respondent on 1/7/2025. Post of para. By the order dated 24/6/2025. The resolution was disposed of by directing the respondent hearing to do the needful. As regards the application submitted by the petitioner for transfer of the subject land in terms of a notification dated 26/03/2021 within a period of 4 weeks from the date of receipt of a certified copy of the order. Post of. Issue notice returnable on so and so steps by steps upon the respondents by speed post within 2 working days more.
17.6. Item 3.
Yes, what is the case about?
Lordship, the plot of land was registered in the name of the petitioner school in the year of 1997. And in the year of 2024, the then secretary of the school filed a revenue appeal challenging the mutation order in respect of the plot of land which was donated by his father. Accordingly, the mutation order was set aside and cancelled. So I have filed the instant writ petition on the ground that first the delay was not condoned. There was a delay of 28 years. Land was mutated in the year of 1997 and the appeal was filed in the year of 2024. In the section 148 candidly says that the limitation period is only 2 months. Yes, there is a provision of the condonation of delay if the deciding authority is satisfied that there was a sufficient cause which prevented the appellant to file the appeal in time. But the order will reveal that delay was not at all condoned and the adjudicating authority remains silent about the delay. And second ground is that, Lordship,
Some land and revenue reverse. Yes, again.
that when someone preferred appeal, it is my legal right that I should have a right to file my written response.
Were you a party in the appeal?
Yes,
You received summons?
I received summons, Lordship.
Right. Where is the revenue appeal? The revenue appeal.
Filed in the page number
Both parties present.
22.
When the revenue appeal order was passed?
It
19.
was passed in 19/11/2025.
5 to 2025. Okay. Come to page 37. So 8/1/2025. Revenue appeal was registered.
Lordship.
Hmm? Notice was directed to be issued.
Lordship.
Then page 36.
Lordship.
You appeared,
I have appeared.
file attendance.
Attendance I have filed.
Did you raise all those questions?
Yes.
Did you raise
Yes,
regarding
yes.
limitation?
Yes, Lordship. Did.
Where it is reflected?
That is why I am before your Lordship. Because the written.
Those are whether you have raised or not.
Yes, I
You
have
can-
raised this Lordship. Even then, if I had an opportunity to file.
Oh, you waited for, you were there from 5 to 2025. You attended the proceedings.
Okay.
Is it not?
Yes, that is true.
And for what purpose you attended the proceeding? Just to show your face?
No.
To show your face
No,
to
Lordship.
the appellate authority? Or for what purpose?
I appeared before to defend myself in the appeal.
Hmm?
Lordship, I appeared before the authority to defend myself while adjudicating the appeal. Lordship will appreciate one thing, that the entire order sheet and the final order, nowhere it is reflected that I was given an opportunity to file my written reply or written statement. The entire appeal is decided in a manner which is not supported by the rules and law. Lordship, when a matter is so cloudy and there is some suspicion that it required a detailed adjudication, but the order will reveal that it is nothing but a summary order, and the appeal is preferred suppressing the material fact also. That Lordship, if Lordship peruse the appeal, then appeal is itself sufficient. That hiding certain facts, they have misguided the deciding authority, and the deciding authority also failed to perform its responsibility and duty as required by the law.
Against the said order, an appeal also lies.
I am before your Lordship because there is a procedural lacuna and
There are
violation.
two aspects to it. One, you said that delay was too long and it was not condoned.
Lordship.
Second, that you were not given the opportunity,
Lordship.
right?
Right.
But you attended the proceeding
That is true.
all throughout,
Yes.
remain silent.
The order says,
Asserting your right. No, all, both the parties are present, file attendance.
Present, Lordship.
Every time
Yes,
it was
that-
there.
That is true, Lordship.
Right.
Not on.
Page 36, it is clear.
I am admitting. I am not disputing, but.
Then,
why
when an
is it
appeal, Mr. So it cannot be said that no opportunity of hearing.
No
You
opportunity.
can argue that no reasonable opportunity of hearing.
Yes,
But you cannot argue no opportunity of hearing.
I am telling that.
And that is not a
opportunity-
case to be, these are all material facts.
No, Lordship, I am.
Why don't you prefer an appeal?
Because
Why
I-
we are going into the records in a writ proceeding? Why will call for the records? Appellate court can definitely.
No, one
Under
thing
what
is that,
47?
Lordship, my humble understanding is that if there is a procedural lacuna and if there is a violation of the natural justice, perhaps I can.
Mr. Mozumdar, it is not a straitjacket formula. natural justice is not a straitjacket formula. Here is a case where you, right from the beginning to the end, your attendance was there.
Lordship,
You were put to notice.
Lordship,
Had it been a case that no notice, then case would have been completely different. You were there. You had all the opportunity to raise all the objections. You did not make any objection. Before that appellate forum, in writing,
I raised. Lordship,
when it is not reflected,
reflected.
discord in re-jurisdiction, this re-jurisdiction is different from appellate jurisdiction. I think you are aware.
Lordship,
Who can examine all the records? If you have filed any hajira, if you have raised any objection, that court will see, revenue board. Why will see all this?
no, Lordship, one
This is
thing,
we are into certiorari jurisdiction. We are not appellate jurisdiction.
that is correct.
Let them see. Then if you are aggrieved still, then you come. Why you bypass a forum? A statutory forum. Every time drop of a hat, you will come to this violation of natural justice. This is not a case. I'll hold. No opportunity of hearing is different. When opportunity of hearing is given and it is not taken advantage of, then you cannot plead and come in a writ petition, say that this law is also settled. It is not a straitjacket one. Just because you attended a proceeding and you have shown your face only without doing any effective steps from your side. Yes, case that allow accepting the appeal without considering the law of limitation is definitely a very good ground. But who will examine?
Lordship, one more
If
thing.
you have waived that right,
Lordship,
now
one,
147.
yes. It is about the authority to have, to whom appeal lies.
Yes, Mr. Hazarika.
Lordship, the petitioner has obtained
Regarding limitation,
limitation. Lordship, yes, there is some provision related. Related
it is
to the-
there, 148.
Yes, Lordship. Lordship, my humble submission notice may be issued in this stage. So I will.
But will not accept your ground regarding no opportunity of being heard. Regarding limitation, it is confined. It is up to you. I hold that these 2 points are urged because no point keeping it. Keeping the petition as regards your violation of natural justice.
What?
We'll only confine ourselves to the point of limitation.
And Lordship, one more.
When it is not the case of no opportunity of hearing, I'll hold.
Lordship,
Heard Mr. F.Z. Mojumdar, learned counsel for the petition. And who is there for revenue or a secondary education department?
Yes, Lordship.
Miss? Miss? Learned Standing Council, Secondary Education Department for the respondent number 1. H.K. Hazarika, Learned Junior Government Advocate for the respondent number 2, 3, and 4. Also, Para, the petitioner has assailed and ordered dated 19/11/2025 passed by whom? Respond number 2 or 3? 3.
3, Lordship.
3. In revenue appeal number 01/2025. Whereby the respondent number 3 as an appellate authority has ordered for cancellation of the mutation made in favor of the respondent hearing, that is Fatehpur SU Academy High School, in respect of a plot of land measuring 5 bighas, 1 katha, 7 lessas, comma, covered by dag number 46 and periodic patta number 2, located at village
Kehutoli.
Gauhati, Moja Laluk, Bigpuria Revenue Circle, District Lakhimpur, subject plot for salt. Close stop. 2 grounds have been urged on behalf of the petitioner to assail the appellate order dated 19/11/2025. Close stop. Firstly, comma, the original the mutation order in respect of the subject plot was, where is the mutation order?
Original, Lordship, Jamabandi is there.
Mutation order. In Jamamandi, it will be reflected only in terms of mutation order.
Mutation order, it is not there in the petition.
Where is Jamamandi?
Jamabandi in page number 18.
18. Oh, No remarks. No remarks.
Lordship. 19 is the original one.
Then let us see. Something is not right. Hmm.
Lordship,
Where is the mediation order?
mutation order, I have not annexed probably.
You go and prepare the appeal.
Lordship.
You follow? Then no limitation. When there is no mediation order, it has surreptitiously and fraudulently made. It clearly appears. Then the fraud vitiates everything. Fraud will not come in the way of limitation.
Lordship.
No. I have seen.
I may be
You go
allowed
for appeal.
one line
You
submission.
go for appeal. Yes.
That the impugned order itself reflects that the applicant have preferred an appeal under section 147, 148 of the ALR against the impugned order passed by Region Circle Officer, Bihopuria Circle Officer.
What against what order? Against what order?
They have preferred the said
Show
order.
me the order in your favor. Show me the order. An appeal is to be preferred against order. An order. Where is your order? How
Okay.
you got into the Jamabandi?
Lordship, yes,
Yes
I-
means yes.
yes, I am stepping one
Then
step.
no date. Then no date.
Then
How you got into the record of rights? And that
Because-
was a clear allegation in the appeal. Paragraph.
the appeal shows Lordship.
Mr. Now I am going to remark adversely on the point of limitation also.
Lordship, I may be allowed because it is in school. No, I may be
No
allowed to
allowance,
submit.
no installment. One installment has been given to you to file an additional affidavit. Wherefrom it is clear that you participated all throughout the proceedings
That is true.
and you failed to produce any kind of document.
They have argued.
So you can, it is not open for you to raise the point of limitation. I did not.
They have asked me. They have asked me.
You better file an appeal, or otherwise I am going to dismiss it without any liberty to file an appeal. Because question of limitation may not come. Because there is no order of limitation. How you got into this Jamabandi, that is not clear. It is very clouded. You fail to produce any document during hearing, all throughout, for a period of
I am-
8
I
to
am-
10 months.
Lordship, I am on that point. I need to explain only one line.
Yes, please.
That the appellant who has filed the appeal, he was the secretary of the school. Until the year of 2016, he was the
We
secretary.
are not going to those facts.
No,
In
why I have
education, I am
claimed
not
for this?
going.
Because it is
I am
under
not
the
going,
custody of the
Mr.
secretary.
Your whole thing is clouded.
Then I may be allowed to go to the revenue board.
Better you go, otherwise I comment you adversely on both the
I may be
counts.
allowed to withdraw and I may be allowed to go to the.
Everything is clouded.
Then also the petitioner could not produce the 11 document.
That I have seen.
That I have stated why I have not, because the.
Still, I
person is-
thought that let notice be issued, but everything is clouded from the Jamabandi. How it has been made, page 19, after making submission. Has some link, Mr.
One report was called from the cycle officer.
Mr.
Lordship,
You want to make any submission? I'll close it.
Lordship, I am not submitting anything.
As submitted that the petitioner be allowed to withdraw the writ petition in order to file an appeal. Revenue Board has all the power to condone any period of delay, so file an appeal under section 147, small a of the Assam Land and Revenue Regulation 1886 before the Board of Revenue, Assam. First of as in view of the and he has submitted that the period spent in the instant proceeding should be considered by the Assam Board of Revenue in the event there occurs any delay in preferring the appeal. First of para. Votes for. In view of the above submission made by Mr. Mojumdar and counsel for the petitioner, the writ petition is allowed to be withdrawn, reserving the liberty to the petitioner to prefer an appeal before the Board of Revenue Assam. Because the petition is observed in the event an appeal is preferred by the petitioner before the Board of Revenue Assam, the Board of Revenue shall take into consideration the period spent by the petitioner in proceed in the present proceeding, while considering the period. Now, in the event any under subsection 3 of section 148, in the event any delay occurs on the part of the petitioner in preferring the application.
Item 4.
Yes, some favors met.
Please, Your Lordship. Lordship, as per order dated 31/3/2026, the petitioners, we were supposed to file an additional affidavit showing that the petitioners are the members of the Bizni Muhukuma Khatigrasta Pattada Saturaka Samiti. But Lordship,
Member, okay. Member is okay. Whether you have land.
Lordship, to show
Whether
that
you
we
have
have
any
sought for
land.
the- Yes, Lordship. Yes, Lordship.
Where is your statement? Where is your statement?
Lordship, we have sought for the documents, Lordship.
Oh, you file it first.
No, we have sought for the documents showing the,
First, you have to show that you are a landowner. You are under some organization.
yes, Lordship.
Organization claimed that our members lost land. So you are one of the members of that organization.
Lordship.
Now you have to show that our lands were there and our names are in the list of beneficiaries and we did not get anything. But your statement is that your name is not in the list of beneficiaries. Am I correct?
Yes, Lordship. Lordship.
So you file the petition first. Then you go everywhere to collect documents. We will not allow this 3 weeks at the motion stage. You come up with better particulars, absolutely vague. Yes, Ms. Bora,
Yes, Lordship.
come to your statement at paragraph 11. Read
Yes.
last line.
Okay, sir.
The names of the petitioners have not appeared in the list of beneficiaries. Oh, you don't have copy also?
So sorry, the senior is not here.
Petitioners' names, para 13, petitioners' name were not included in the list of beneficiaries for the last 8 years.
Yes.
Madam, we can't permit you 3 more weeks. Come up, ask Mr. Das to come up with better particulars. We are closing it, giving you liberty. This is not done. You file it and you go on praying for time.
Lordship, I'll take instructions from
Take your instruction. I am closing it, giving you liberty to file affairs. Don't come with vague particulars.
kindly grant us liberty to file an application. Much
Alright,
obliged.
Miss
Dear Bangshari,
Learned Counsel appearing for Mr. S.C. Das, Learned Counsel for the petitioner. Miss Bora, you're for?
456. 456.
Miss R. Bora. Learned Standing Counsel, NHIDCL for the respondent number.
NHAI, Lordship.
Huh?
NHAI.
Okay, NHAI for the respondent number 456. Mr. H.K. Hajorika, Learned Junior Government Advocate, Assam for the respondent number 3. Miss A. Gayon, Learned Junior Central Government Council for the respondent number 1. N. Bodulo, Standing Council Revenue for the respondent number 2. Para Miss So-and-so, Learned Council for the petition has submitted that the petitioner may be allowed to withdraw the petition with the liberty to file a phrase with proper details.
much obliged.
In view of the above summation made by Ms. So-and-so, the petition is based on withdrawal with the liberty as prayed for.
Much obliged, Lord.
All right. Item 6.
Yes, madam.
Lordship, as per the order passed in the earlier repetition, the closure amount has, which is laying in the account of Julie Chaudhary has already been remitted, Lordship.
Anything?
Yes, Lord.
How much was the amount?
18 lakhs 94,434.
When? When it was remitted?
34/2025, Lord. Through speed post. And
Money
five-
can be remitted through speed post.
Yes, Lordship. One DD, Lordship.
Okay, DD.
Yes.
DD. Whether it has been credited.
I don't know, Lordship.
Mr.
My lord, as per earlier it was credited, my lord. So for account number, my
Let us
lord,
see the order first.
Yes, Lordship.
150.
29/01/2025.
Yes.
What was the direction?
Page number 24.
Page number 25.
5.
Having it summary, it appears that what's correct? That is correction. But where is the main order?
Page 26.
24.
Is the operating question.
Line in the bank
And
account number so and so with the
Earlier, first order is page 23, my lord.
I'm reading it. Paragraph 7.
Paragraph 7, my lord. This was in respect of, my lord, account number 150,370,4408. And now
According to you, what was the amount in deposit?
my lord, I don't know because
You
it was
don't know.
not disclosed, my lord.
In April, 18,94,434.
Yes,
Yes,
Lordship. It was
Point-
laying in the account.
Huh?
It was laying in the account of Julie Chaudhary, Lordship.
Have you confirmed that the DD has been encased?
No, Lordship.
You have the information.
Yes, Lordship.
You have the information.
Yes, Lordship. Give me some time, Lordship.
To get the find out whether it has been encased or not.
My lord, in respect of another, my lord, saving bank account, I have mentioned in my, my lord, representation dated 10/2/2026, my lord.
No, Mr. Ziuddin, the direction is for paragraph 7 is this one.
But,
In the earlier.
earlier I have no grievance.
Ah.
So for account number, my lord,
Where is the representation?
that is page 10, 27.
What was the earlier bank account number?
1503704408.
It is mentioned one of the two. Mr. Uddin,
Lordship.
why you are indicating it? The other account is in Punjab National Bank.
Yes, no.
Firstly.
Yes.
Secondly, Punjab National Bank is not a party here.
Yes.
Let you resolve this. You want to pursue any proceeding, pursue it against Punjab National Bank.
I'll pursue.
So that is a different matter.
This,
We are concerned with this.
yes, sir.
Central Bank of India.
Yes.
Is it not?
So Lordship may kindly see, last minute, prayer question, my lord.
Prayer of the repetition.
No, my lord, my representation, my lord. I have
No,
filed two
I'll
representations.
not, Mr. Uddin, I'll not go into it because that account is in Punjab National Bank. Punjab National Bank, your
Another-
statement,
No, my lord.
please see.
This is, my lord, to the branch manager, Central Bank of India, Punjab, Panbajar branch. Address.
Mr. Uddin,
Yes, my lord, sorry.
paragraph 3, please read loudly then.
There is another grievance also,
Please
my
read loudly then.
Lordship, my lord.
If there is miscommunication between you and me,
Lordship.
Julie Chaudhary appointed me as nominee of United now Punjab National Bank account number so and Central Bank of India Ulubari. Account numbers are mentioned, right? That account number is 1503704408, right? Come back to page 23. So 23. The direction is in respect of this number ending with 4408 with the Central Bank of India.
Yes, my lord.
You are aggrieved in this repetition for that?
No. Regarding fixed deposit and other banks. So that's in prayer portion, my lord.
So have you received this 18 lakh?
Yes, yes.
You have received.
Yes. That I have no grievance on that.
Earlier under repetition, you have no grievance.
Now subsequently I filed representation manual because there is a fixed deposit also and another bank account, saving bank account also. My prayer is transfer those manual amount to this manual 1503704408 where I was nominee, madam.
Yes, madam, there is another cause of action.
It's not so.
And my lord, I have made also alternative prayer
Mr.
in page 29, my lord, if to transfer the amount to the ISKCON also, my lord. This reminder also they received, my lord. Page 29 and extra letter.
Madam, you get instruction regarding para 4 of page 27. Heard Mr. Giuddin, the counsel for the petition, Miss. Yes, Yasmin, learned counsel on behalf of Mr. M. Sharma, and standing counsel, Central Bank of India. Mr. Uddin has submitted that pursuant to the direction given in the order dated 29/1/2025 in WTC number 308/2024, read with the order dated 28/3/2025 in I Civil 844/2025, the amount stood deposited in the savings bank account number 15037044408, maintained by late Nolini Kumar Chaudhuri and late Julie Chaudhuri, with the Ulubari branch, Central Bank of India, had been transferred to ISKCON,
KCON.
KCON, Gauhati. Full stop. In this petition, the petitioner has mentioned that late Julie Chaudhuri had fixed deposits with the Ulubari branch Central Bank of India with what is this 179?
My lord, this is another saving bank account, man, in the name of that couple.
You say fixed deposit, then again you say savings bank account
Yes, in prayer.
and
petition, my lord.
fixed deposits. Apart from a savings bank account number 179-174-3016.
Okay, very funny.
Apart from full stop. In this situation, the petitioner has mentioned that late Julie Chaudhuri had fixed deposits and a savings bank account number 179-174-3016 in the same Ulubari branch.
Lordship, it should be on Panbazar branch, I guess. This saving bank account. Because they have made representation to branch manager, Central Bank Panbazar branch.
Panbazar.
But you made Ulubari branch manager.
That's why, Lordship. That's why I got the instruction from the Ulubari
You
branch.
made all the confusion.
My lord.
Yes.
Sorry, my lord, this branch, my lord, but whatever. my
You
lord,
don't take an
address,
last 10-15 minutes, I am trying to solve the puzzle.
my lord. But I'll take instruction, my lord.
File with proper particular, why we are wasting judicial time?
No, only my lord, it is.
Just because you are a devotee will not give you more time. Mr. Uddin Learned Counsel for the petition is allowed to withdraw the petition with the liberty to file the petition with proper particulars and with proper respondents. Ms. S. Yasmin Learned Counsel, on behalf of Mr. M. Sharma, Learned Standing Counsel, Central Bank of India, is present. You claim from some other ones, you make some other party. You have created the confusion. So for last 10 minutes, I was trying to solve the puzzle for you.
Sorry, my lord.
Just
but-
because you are a devotee.
Yes, my lord.
Just because you are a devotee. I tried to be with you.
I'll correct it.
Item 7.
May it please your lordship. My lord, the petitioner before lordship, he is my lord secretary of a cooperative society. My lord, so appointed in 2005. In 2024, my lord, by a resolution, purported resolution, my lord, he was removed. And the my lord chairman appointed his brother-in-law as the my lord secretary in place of the petitioner. Then my lord, he filed an appeal before the my lord joint general registrar, and general registrar my lord, he stayed that order of appointing the private respondent as secretary. Now, my lord, when that was pending, my lord, writ petition was filed before this honorable court by the my lord private respondent number 13. And my lord, this honorable court eventually held that an appeal does not lie. Against that, my lord, an appeal was filed, and the appellate court has, my lord, held that an appeal lies, and therefore directed that the appeal be disposed of. Now, the appeal has been disposed of by the impugn order. What I am on is that, my lord, while removing the petitioner, firstly, my lord, as I said, it is a purported, my lord, resolution. There was no agenda item regarding the service of the petitioner. Then, my lord, it was not held properly, and there was an inquiry conducted by the, my lord, the deputy commissioner through the ADC. And that report also, my lord, has clearly stated that whether the meeting was held at all, or my lord, it was subsequently, my lord, incorporated, that is also very doubtful. In spite of that being on record, my lord, my lord, the appeal of the petitioner has been rejected by the impugn order, my lord. Against that, I have come before your lordship.
He says records were verified.
My lord,
Records were verified.
that is what he says, my lord. If your lordship kindly comes to the inquiry
Standing
report,
Counsel will produce the records. Yes.
and my lord, showing the record, my lord, if your lordship kindly comes to the inquiry report at page 86, my lord, that is the report that has been conducted by the, my lord, ADC and submitted to the deputy commissioner.
But you are out already.
In fact-
Initially, since when you are out?
In fact, my lord, there was a stay order, and my lord, after your lordship passed that order, then my lord, although my lord, he is my lord required to hold, the private respondent is required to hold search. Till now, my lord, he is not working. Till now, he is not working. Anyway, my lord, that
I am direct to maintain status.
I am
quo.
little piteous article, my lord, since then, my lord.
Status quo, whoever is there.
Yes, my lord.
Heard Mr. M. K. Chaudhary, Learned Senior Counsel, stated by Mr. M. Khan, Learned Counsel for the petition.
Oh, my lord, I'm sorry, my lord. Since the order is not, my lord, cryptic, and I'll show from the record has not been consulted, can it be reverted back to the, my lord, my lord, appellate authority to decide it afresh, my lord?
No, first we have to hold that.
The records were
The
not
records
verified.
are not verified. Otherwise, how can we, at the instance of the petition,
My lord.
Miss S. A. Buck, Learned Counsel on behalf of Mr. S. K. Talukdar, Learned Standing Counsel Corporation deferred. For the respondent number 154 and Mr. B. Sinha, Learned Counsel, who has entered appearance on behalf of
For caveat, I have for 13, but I will appear for all private respondent, board members.
Who has entered on
6 to,
behalf of the respondent number
6 to 17.
13. Caveat is filed by whom?
5 by 13, my lord. Respondent number 13.
Respondent number 13. On the strength of a caveat, first of, Mr. Sinha has further submitted that he has instruction to appear on behalf of
So number 5 to 17, madam.
respondent number
respondent.
5
5 to 17.
to 12
No,
and respondent number 14 to 17 also. First of, in this petition, the petitioner has mounted a challenge to an order dated
7/5/2026.
page
Page 85.
7/5/2026 within bracket annexer 12 passed by the respondent number
2.
2 in an appeal referred by whom?
By the petitioner.
By the petitioner against an order, against a resolution allegedly taken by the board of directors of the of Messrs. Rajeshwarpur Samabhay Committee Limited in a meeting dated in a meeting held on 4/12/2022, whereby the petitioner's appointment as the secretary of the said registered cooperative society has been cancelled.
And the private respondent has been appointed.
And in his place, the private respondent number 13 has been appointed. In the impugn order, the respondent number 2 has observed that records were verified. On verification of the records, it was not found that there was proof of inserting the said resolution. First of, in the appeal, the petitioner had alleged that the resolution dated 4/12/2025 court was fraudulently entered into the resolution register of the registered cooperative society after keeping blank space therein, and the said resolution was thereafter and by the said resolution, the respondent number 13 was subsequently appointed as the secretary of the society. Post of having regard to the aforesaid projections made by the petitioner in its appeal and the recording of finding by the respondent number 2 in the appellate order dated 7/5/2026, the relevant records, a perusal of the relevant records would be necessary. Post of, let notice be issued as so and so has appeared, except its notice on the. Yeah, file nama.
Yes, madam.
For all.
No, for 13 only, the other way I will file.
And for the said respondents, he will be filing the Ukalarma by the next week.
Yes, next week.
Within 1 week from today.
Yes, ma'am.
So as Ms. So and so appeared accepted, Sinha Gudeta DD was
5/2/17.
17. Let notice be issued. As all the respondents are represented, the notice is made returnable on so and so at a clock did you? In your talk.
5th June, 5/6.
Learned counsel paying representing the respondent cooperation department shall make endeavor to produce the relevant records of the appellate proceedings as well as the proceedings of the board of directors of the society. Highly appreciated. Already directed. Extra copy, requisite number of extra copies. Always.
Item number 8.
May I please your lordship. Here, my lord, petitioners are a cultural club registered under Societies Act and other foods are, my lord.
Yes,
local
madam.
public.
They are saying that somebody has encroached your land
Lordship, railway land, lordship.
and you are keeping silence. Yes, this foundation stone has been laid.
Lordship, otherwise, lordship, it's railway land. Whom to, that is the,
Get
up
the
to
facts
them,
clear,
lordship.
heard Mr.
R. Sharma, my lord.
R. Sharma, land counsel for the petitioner. Petitioners. Miss P. Sharma, land central government counsel for the respondent number 1. Mr. Talder, you are appearing. Mr. B. J. Talder, as senior counsel, is said by Mr. P. Huh? H. Chetri, Learned State Council for the respondent number 2. Mr. Peanut, Learned Standing Council,
3, 4.
ZMC, and PWD for the respondent number 3 and 4. Postal. The instance writ petition has been preferred under the AEGIS, AEGIS of the petition number 1, which is a registered,
Registered, my lord.
registered society.
Cultural club registered
That
under.
Societies Registration Act, wherein the other petitioners are members. First of the cause espoused by the petitioners hearing is that a public playground commonly known as Kati View Field at Maligaon, Gauhati, within ward number 12, Gauhati Municipal Corporation, are being used for common activities, community activities, and said the land of the said and the said vacant plot of land belongs to the respondent number 1, that is Northeast Frontier Railway. Postal. The petitioners have approached this court stating that the respondent number 5, who is a ward councillor of ward number 9, ZMC, has suddenly started construction activity of an auditorium stroke committee hall in the said vacant plot of land belonging to the respondent number 1. Post of the petitioners have stated that they have represented before the they have made representations before railway.
My lord.
As well as GMC.
DMC, my
Before
lord.
the respondent number
District Commissioner also, my lord.
before the respondent number 1 to 4, as regards the alleged illegal activity of the respondent number 5, but no action. Because of the petitioner have further stated that having seen that as the respondent number 1 to 4 seem to have taken no interest in the representation, the petitioners are compelled to approach this court by the instant petition. Issue notice returnable on so and so, as so and so appeared accepted notice. Issuance of formal notice dispensed with extra copies, requisite number within 2 working days from today. A petitioner shall take steps for service of notice upon the respondent number 5 by speed post within 2 working days from today.
It's a construction of the auditorium is going on here.
I'm not stopping.
Not so.
Yes, not.
I'm not stopping.
Not.
Let us see the validity.
15-6.
Only that much.
Item number 9.
And Mr. D. Bora. Learned counsel for the petitioner. And Mr.
C. Paul,
C. Paul.
appearing on behalf of KP Pathak.
Okay, learned counsel on behalf of Mr. KP Pathak, learned standing counsel,
APDCL.
APDCL, for the respondent number 1,
1, 2, and 3.
1, 2, and 3. And Mr. Your huh? Huh? Okay, 1 and 3.
Yes, sir.
And Miss K. Das, learned counsel on behalf of K. Fukun, learned standing counsel AEGCL for the respondent number 2. And Mr. State Counsel, Mr. S.S. Roy, electrical advisor, electrification date. You have to file the report. Mr. S.S. Roy, learned Union Advocate of Assam for the respondent number 4 and 5. Full stop. The petitioner has approached this court by the instant writ petition seeking compensation from the respondent authorities in the APDCL/AEGCL on the ground that the petitioner's husband had died on 22/7/2025 due to electrocution. Full stop. It is stated that the petitioner's husband got electrocuted when he was passing nearby an electric tower line of 11,000 volt, which after getting snapped, was lying on the ground of the petitioner husband's paddy field, right? Okay. Issue notice. Returnable on so and so. As so and so, requisite number of extra copies. The respondents shall ensure that their counter affidavits are filed on or before the returnable date. So the respondent number 4 shall ensure that the electrical accident inquiry report is part of its counter affidavit. Respondent of 4 and 5. Shall ensure. Are to ensure.
May I
Yes.
pray for a fixed date, my lord?
Even
17-6.
Much please.
the name of the learned government advocate be reflected in the respondent side in the Assam, be reflected in the respondent side in the court list.
Maybe legal. My lord,
I have grievance against respondent 3, circle officer. Respondent 4 may be a misjoinder. What, sir? You are 5 years earlier, partial appraise.
Yes, Lordship.
What? 5 years? Even money claim is out of limitation. Page 26.
Yes, Lordship.
Now it is a process under RTPS.
Yes,
You file an appropriate application.
Yes, only
Then
that.
they will be answerable.
Yes,
This is the only application.
this is only application.
That was in 2001.
Yes.
And you also remain silent. Is it not? Or Mr.
Yes, sir.
Sarkar, Rambabu Singh. That was in 2021, this notice.
Yes, and some objection was also filed at that time. 11.
Is there a disputed thing?
My lord, neighbor is, my lord, disputing something, but demarcation, my lord, does not ascertain any right and liabilities. I am only asking for a demarcation. That has not been done. Only they will demarcate it, my lord. No right.
While this is not the process also, they would
Yes.
not go ahead.
Yes, then Lordship may relegate some observation, my lord, I'll approach.
Reduction demarcation. Heard Mr. S.K. Talukar, learned counsel for the petitioners. These two are brothers or what?
Yes, yes, son and father. my lord.
Okay. Miss N. Bodulu, learned standing counsel, Revenue Department, for the respondent number 1.
I'm for 2,
And
3,
Mr. N. Goswami, learned junior government advocate, for the respondent number
2, 3 and
2, 3, and 4.
4. Yes, Lordship.
Okay. For 4, the petitioners have claimed that you are co-owner.
My lord, yes, co-owner, my lord, yes.
The petitioners have claimed that the petition number 1 is a co-owner of a plot of land measuring 1 katha 3 lesa, covered by tag number 252 and NIS Khiraz Patta number 94/1, situate at which place?
Mongoldoy town, my lord. In the notice, my lord, village Mongoldoy town, Moza Sopai, page 26, my lord.
Oh, now it is due tag number.
A new dog number, yes.
Okay. Okay, itu baad diyo tumne. Ekini baad diyo. Petition number 1 is the absolute owner of a plot of land measuring 11.5 lesa, covered by tag number 1615 and periodic patta number 611, situate at village Mongoldoy town, Moza Sapai, Mongoldoy Revenue Circle, District Dorong, subject plot. It is the case of the petitioners that an application seeking demarcation of the subject plot was submitted before the respondent number 3 on 15/7/2021. And on receipt of the application, the respondent number 3 registered a miss case 10/2021-2022. During the course of the said proceeding for demarcation, the respondent number 3 also issued a notice to one of the neighbors of the petitioner. Sorry, to the petitioner. To one of the neighbors of the petition, but despite elapse of, but thereafter, no, but the proceeding came to a standstill. Standstill?
My lord, was not processed further, my lord.
Mr. Ms. Bordoloi and Mr. Goswami, learned counsel appearing for the respondents, have submitted that more than 5 years have elapsed, about 5 years have elapsed since the proceeding. Near about. Since initiation of the proceedings of Miss Case number 10/2021, that's 2022. Full stop. At this distant point of time, it would be difficult to retrieve the records of such proceedings. Full stop. They have submitted that demarcation is a notified service under the Assam Right to Public Services Act 2012, and therefore the petitioners are required to submit a fresh application for demarcation as per the prescribed procedure by depositing the requisite fees. 5, 6, 7, 8, 9. Petitioners credible. You file it as per online.
Disposal.
Disposal. Then if you are aggrieved, you prefer appeal?
My lord, yes, I'll pay. My lord, obliged.
Item 12.
Lordship, I'm praying for a short pass over, Lordship. Lordship, item number 12 and item number 18 are similar matters, Lordship. Lordship, we hear both the matters with.
12 and 8.
Okay. Item 13.
May I please, Lordship? Lordship, matter related to freezing of bank account.
Yes, Mr.
Yes, Lordship. Lordship, matter related to freezing of bank account. Lordship.
Hard Mr. J is now. You are appearing for
Bank, Your Honor.
bank. Which bank?
Respondent, all the respondent, Your Honor.
All the respondents.
Bank of Baroda.
Bank of Baroda.
Bank of Baroda. Since when it was kept on hold?
Lordship, last transaction was done, Lordship. Is 17, Lordship. 21/10/2024, Lordship. And this has been done, Lordship, without any intimation, Lordship. And the petitioner has been
9,26,000 is in deposit.
no, Lordship.
Huh? In the bank or what? How much is in deposit now? 13 rupees 28 paisa.
That I had to take the instruction.
No, from the statement, Mr. Counsel. What is the balance?
Lordship,
13 rupees 28 paisa.
yes.
Huh? That is
Lordship, now.
under hold.
And no, Lordship. Total amount hold, Lordship. As per my information, Lordship, 6,20,000, Lordship. Minus amount of fund, Lordship, 5,88,000.
Where is that entry? 6 lakh.
Lordship.
Uh,
In my statement, Lordship.
which page? 6 lakh entry.
Lordship, para 2, Lordship.
No, not para 2. You have annexed the statement. Take us to the statement.
Yes, Lordship.
In the statement, it is reflected.
Lordship, what happened, Lordship? Now I am unable to upload, to collect my statement also, Lordship. All operating system has been closed, Lordship. I have communicated to the bank manager, Lordship. They have not replied.
Your transactions does not otherwise your transactions were on the later side. Suddenly On 39/2024, 5 lakh,
This statement, Lordship, last
5 lakh
statement,
got credited, then 5 lakh got withdrawn.
now it is shown in the. Lordship.
Accept this amount, otherwise your transactions are very minuscule. 500, 2,000.
Lordship, that big amount, for that purpose, I have, Lordship, mentioned in my statement, Lordship, how that amount.
But
has
you have-
come, Lordship.
Withdrawn all this.
Yes, yes, Lordship, I have.
Now 13 rupees 28
Yes,
paisa.
Lordship, according to me, 22,000 should there, Lordship. Now it is shown as minus 5 lakh, 98,000, Lordship.
Well, you should notice that this is hard.
Let Lordship, status may be called for, Lordship. Even, Lordship, I'm unable to collect the statement also right now, Lordship.
J.
Everything
Islam,
has been
Learned
closed.
Counsel for the petition, and Mr.
Usaikia.
U. Shoikia, Learned Counsel, on behalf of all the respondents. First one. The case of the petition has stated that he maintains savings bank account number para to the at Dhubri branch of Bank of Baroda, which was opened on 2/3/2024. Post up. However, subsequently, the petitioner came to learn that the respondent bank authorities have freezed the bank account showing a balance as within bracket minus sign rupees 5,98,000. Post up. The respondent bank authorities, it is the case of the petitioners that the respondent bank authorities, without any notice, have freezed the bank account of the petitioner. And the petitioner, when the petitioner approached the respondent bank authorities, they have refused to disclose any information as regards the reason for keeping the bank account in freezing condition. So you should notice returnable on soins. As Mr. Soikia, Learned Counsel, has appeared and accepted notice on behalf of all the respondents. Issuance of formalities to the respondents is dispensed with. The Learned Counsel for the petitioner shall furnish requisite number of extra copies of the requisition along with annex to Mr. Soikia within 2 working days from today. The respondent shall file its counter affidavit before the returnable date.
Lordship, on typical error, Lordship, in the barrier part, I may be allowed to.
That is not promised. You approach the registry.
Okay. Be published, Lordship.
May it please, Lordship. On the basis of the application, my lord, and as well as the Mondol report, a case was initiated by the but hearing was conducted, no final order has passed, my lord.
When hearing was conducted?
Your Lordship will find page 38, my lord.
38.
15/7/2025, my lord.
18. Yes. Heard Mr.
R. Islam.
R. Islam, Learned Counsel for the petitioner. Miss N. Borole, Learned Standing Counsel, Revenue Department, for the respondent number 1, and Mr. J. Henry, Learned Junior with Assam, for the respondent number
2 to 5.
2 to 5. Get instruction whether it has been brought.
Dispose of.
Disposed of or not.
Yes.
So otherwise you will issue notice.
Lordship, can it be issued, my lord, short notice, Lordship, within 2 weeks?
Short
Lordship?
notice, that will take. Bibadi Poikho. What is the case registered? For what purpose?
For deletion of the name of illegal tenant, my lord. Your Lordship.
The petitioner. has filed an application, Find out if it is pending, then we'll issue notice.
Lordship.
Had filed an application seeking deletion of names of what?
Tenants, my lord.
Tenants
Yes.
from
From my lord,
Patta or what?
Sita, my lord. Sita.
Huh?
Sita copy.
From the Sita records.
Yes.
And on receipt of the application, comma, the respondent number 5 registered the same as miss case number BPC stroke miss stroke 363 stroke 2025. Full stop. After registering the case, comma, the respondent number 5 issued notice says to the opposite parties whose names stood incorporated in the Sita records as royalty possessors.
Yes, my lord. I think.
First off, the petitioner stated that on 15/9/2025, a hearing took place in connection with miss case number so and so. First off, but the respondent number 5 has not passed any final order till date. First off, aggrieved thereby, the petitioner has approached this court by the present rate petition. Mr. Hendrik, learn it in your government pocket. Shall obtain instruction whether any final order has been passed by the respondent 5 in miss case number so and so. And if passed, when such order has been passed, and if not passed, comma, within the time period within which the final order is expected to be passed. You need any instruction? Copy? 1 week? Get the instruction is there.
Lordship.
List the case on so and so. To after 1 week to enable Mr. Hendrik to obtain the instruction above instruction.
2505.
I got this.
Item 15.
May I plead the lordship? Lordship, the petitioner is the legal heir of the original Pattadar and general power of attorney holder of recorded Pattadar, namely Hemakanta Buru, Pramod Buru, and Durga Buru. Then the petitioner and the recorded Pattadar, they have been enjoying peaceful possession of the said plot of land measuring 1 katha 4 lessa, covered by Dagnong 367, KP Pattanong 348, situated at village Pub Boragao under Moja Zalukbari under Gauhati Revenue Circle. But on 13/11/2025.
Now, what about the demarcation proceeding?
Yes, madam. Two notice was issued regarding demarcation, but due to the absence of the private respondent, it was incompleted. But they are tried to dispossess
the petitioner.
Possession, disposition, we are not into it. You have clearly stated that in the synopsis, without any right, title, and interest, attempted to forcefully encroach. We are not into it. And start unauthorized construction. We are not into it. That is a jurisdiction of the civil court. If any restoration of possession is required, go to the civil court.
Then
Yet what about the demarcation?
demarcation, see.
Take instruction.
Heard, Mr. We are not into this possession, restoration of possession. P.A. Ahmed, learned counsel for the petition. Miss Ann Borole, learned standing counsel, Revenue Department, for the response number 1. Mr. J. Hendrik, learned Junior American Assam, for the response number
2 to 4.
2, 3, and 4. Full stop. Para. The petitioner is a the petitioner's father. Late Padmaram Boro and his paternal uncles. Were are co-paternals, were stroke are co-paternals in a plot of land measuring 1 katha 4.89 lasses, covered by Dag number 367 and KP Patta number 348, situate at Revenue Village, Boragaon, Moja Jalukbari, Gauhati Revenue Circle, District Kamrup Metro, some subject for some. And the petitioner has instituted the instant writ petition as a constituted attorney. It is the petitioner has stated that an application for demarcation of the subject plot was submitted before the respondent number 4. And on receipt of the application, the respondent number 4 initiated the process of demarcation by issuance of notices dated 4/12/2025, Annexer 8, and dated 19/12/2025. Full stop. That's fixing the dates 12/12/2025 and 23/12/2025 as for demarcation of the subject plot. Full stop. The notices were also issued to the opposite parties for their presence at the time of demarcation. Full stop. It is the grievance of the petitioner that despite initiating the process of demarcation in the month of December 2025, the demarcation proceeding has not been brought to a logical conclusion. Full stop. In view of the above projection made on behalf of the petitioner, Mr. Hendrik Swenso shall obtain instruction as to whether same. As to whether
25th. 2505.
as regards the present status of the process of demarcation in respect of the subject.
Lordship, it should be respondent number 3 instead of respondent number 4.
Circle officer,
Oblige, your Lordship.
Item 16.
Better part is not filling of bank's account, my lord.
Easing of bank account mallet, petitioner mallet. The petitioner mallet is the saving bank holder mallet of HDFC Bank mallet. And his account mallet was kept on hold mallet, 4 occasion mallet. Come to page 14 mallet. One mallet first hold, it was hold on 7/8/2025. Thereafter mallet 25/9/2025. Thereafter mallet 1/10/2025. Lastly mallet on 5/11/2025.
Heard Mr. has filed and counter for the petitioner. And Mr. S. Roy Leonard, Uniform Advocate for the response number 5.
4 and 5.
Mumbai,
Oh, sorry, Lordship. 5 only.
full stop. The petitioner maintains a savings bank account number Peraturas. And at Rukmini Gram branch of HDFC Bank Limited. And he also holds a credit card bearing number Peraturas. Full stop. The petitioner's said bank account was kept on hold on 7/8/2025 for an amount of rupees 1155.00 by the respondent number 2 on receipt of a complaint filed in the National Cybercrime Reporting Portal, NCCRP. Again on
18 on mallet.
25/9/2025. The bank account. It was informed to the petitioner that an amount of rupees 18,000 has been kept on hold on receipt of a cybercrime complaint filed in NCCRP. Subsequently, also on 1/10/2025 and 5/11/2025, the petitioner has been informed that the temporary alien has been put in the bank account for amounts of rupees 1155.00 and rupees 2000.00 respectively on receipt of cyber crime complaints filed in NCCRP. The petitioner submitted a number of applications before the respondents number 2 and other authorities for clarification as regards the withholding of the bank account. Yes, what happened?
My lord, thereafter, my lord, petitioner had approached, they had sent the email, my lord.
Hmm?
Petitioner had raised his grievance, my lord, for the sending email, my lord, to the respondent authorities, my lord. Page 18, my lord, your lordship will find, my lord, it is to the
Page?
cyber crime, my lord, page 18, my lord. He had requested to complete the process at the earliest and also to restore the bank account, my lord.
As a result, the petitioner's personal loan
Also effect, declared NPA.
has been declared
NPA.
as NPA, and the credit card has been suspended,
Yes.
right? Issue notice returnable on so and so. Issue notice to the respondent number 2, 3, 4, and 5. So the notice is made returnable on so and so. At this stage, it is not necessary to issue notice to the respondent number 1. As Mr. Roy has appeared and accepted notice on behalf of the respondent number 5. Issuance of formal notice to the said respondent is dispensed with. The counsel for the petition shall furnish an extra copy of the writ petition along with an extract to Mr. Roy within 2 working days from today. The petitioner shall take steps for service of notice upon the respondent number 2, 3, and 4 by registered post with AD. Why you have made respondent number 4 a party? How come you know that they have filed a complaint?
My lord, here the
Why is the environment?
cyber cell, my lord. Because my lord, the petitioner submitted.
Where from?
Cyber cell also, my lord.
No, that is the Mumbai police.
Ministry of Home Affairs, my lord.
That is Mumbai police, or what is CB?
Crime branch.
Crime branch.
Crime branch. Where we made any environment regarding respondent number 4?
My lord, paragraph 6, my lord.
Paragraph 6.
Page 6, my lord.
No, by sending notice, you cannot make a part.
Fine.
Because he may notice is a serious matter.
Yes, my lord, because here, my lord.
Where from? You can say that he is involved behind the freezing. Respondent number 1, in the absence of any details, notice to the respondent number 4 is not necessary at this stage. I'm not issuing notice. What happened once file a petition, court issued notice to all without looking at it. Then notice went to the President of India. That magistrate lost his post.
Well, right now,
No environment. How come this has been made party? Respondent number 4. There is nothing. Okay. Buঝলেন? One to নিলুয়ে RBI, promotional. The steps, speed post, 2 and 3 only.
17
unnecessary party.
I will.
17-6. Item 17.
My pleasure, Lordship.
Matter is to freezing of petitioner's bank account.
Heard Mr. S. Islam, learned counsel for the petitioner. And Mr. S. S. Roy, you appear for? Yes, madam, you appear for? Miss Y. S. Yasmin. Learned counsel on behalf of Mr. M. Sharma. Learned counsel for the respondent number 1, 2, and 3, and Mr. S. S. Roy. Learned junior government advocate for the respondent number 4. Full stop. The petitioner company maintains a bank account number so and so at Ongagor branch of ICICI Bank Limited. Number 2 GB.
The party name for. Yes. Correction.
The petitioner, it is the grievance of the petitioner that on and from 18 to 2026, the said bank account of the petitioner has been kept on hold without any prior notice and any complaint. Full stop. Issue notice returnable on so and so. As Miss Yasmin has appeared and accepted notice on behalf of the respondent number 1, 2, and 3. And Mr. Roy has appeared and accepted notice on behalf of the respondent number 4. Issuance of formal notice to the respondents is dispensed with. The learned counsel for the petition shall furnish requisite number of extra copies of the requisition along with an extra to the respective counsel for the respondents within 2 working days from today. The respondents shall ensure make shall ensure that its responses are filed on or before the returnable date.
17.6. Item 19.
Lordship, in this case, GA name may be reflected in the cause list law.
The name of the learned government advocate Assam is to be reflected in the respondent side in the cause list.
And being made major lordship. In this case, I am basically against the, my lord, inaction of the, my lord, Jaspur Municipal Board, my lord. The lordship kindly see annex up 4 at page 37, my lord. Page 37.
Well, issue notice at this stage.
Issue notice.
Art Mr. T.J. Mohanty, Learned Senior Counsel. Pasted by Ms. P. Sharma, Learned Counsel for the petitions. Mr. Roy, you appear for
1 to 4.
Junior Government Advocate Assam for the respondent number 1 to 4. First one. The petitioners have stated that they are recorded co-partakers of a plot of land measuring 1 bigha, 15 lessa, covered by DAG number 593 and periodic patta number 99, situated at ward number 10, Civil Hospital Road, Tezpur Town, by way of inheritance. First up. And the petitioners have stated that the respondent number 8, 9, and 10, without any permission from the competent authorities, including the respondent, Tezpur Municipal Board, have been continuing with a construction work of a building. When complained before the respondent Tezpur Municipal Board by the petitioners, the respondent municipal board, Tezpur Municipal Board, issued directed the respondent number 8, 9, and 10 to stop the construction work which is being carried out particularly in the land of the subject lands belonging to a petitioner. Post of though a hearing took place on 16/7/2025, the respondent Tezpur Municipal Board authorities have not proceeded further to stop the construction of or to stop the unauthorized construction which is being carried out by the respondent number 8, 9, and 10. Agreed thereby, the petitioners have approached this court by the extended petition. Issue notice returnable on so and so. As Mr. Roy has appeared, accepted notice on behalf of so and so, issuance of formal notice to the said respondents. If dispensed, the petitioners will take steps for service of notice upon the respondent number 5 to 10 by speed post within 2 working days from today.
I have a small pair, my lord. For interim, your lordship kindly issue notice, my lord.
Okay, notice is also issued on the interim period. What is it?
96. Deeply.
Bistu Martin,
I'm sorry to say, some inadvertent mistake is remained in this read petition. Last page is remain left out, my lord.
Item 20.
Item 20. After I have given in the index, but page number is remain absent.
Mr. M.U. Ahmed.
Yeah, ma'am.
M.U. Ahmed, accountable of petition has submitted an inadvertently, comma, an annexer is left out to be enclosed with the repetition post of here sought for a week's time to carry out the necessary correction. Post of in view of the above prayer, let the case be listed again on so and so.
2506.
Mr. M for 1 and 3. SS Roy. 1 and 3. Point number 1 and 3. 1 and 3. And Miss S. Yasmin. Learned counsel on behalf of Mr. M. Sherman, learned counsel for the respondent number 2 are in attendance.
Obliged.
Time being matters, items 12 and 18.
My lord, can you take up item 18 below?
Yes. 18.
My lord.
Lordship, please for the. Lord, the petitioner in the present case, in challenging the seizure of cash as well as some debit cards and other instruments by the GST authorities. Now, Lordship may kindly look at section 67.
Yes, GST.
The chart is not की किसी को इसमें याद है.
Yes.
Section 67 empowers the authority for such a seizure. And Lordship may kindly see me, Lord. I may take your Lordship to 2, subsection 2, my lord. Where the proper officer not below the rank of the joint commissioner, either pursuant to an inspection carried out under subsection 1 or otherwise, has reason to believe, my lord, has reason to believe that any goods liable to confiscation or any document or books of accounts which in the opinion shall be useful for the relevant for the proceeding under the act are secreted in such a place, he may authorize so and so to seize the so and so. Now, my lord, what he can seize is the goods, books of account, or things. Now, goods have been defined section 252, my lord.
ये नशा है भाई किताबों पर
Yes.
well, goods means every kind of movable property other than money and so and so. So, my lord, goods means any movable property other than money. Now, money has been defined to 72, 75, my lord.
Yes.
Money means the Indian legal tender or any other foreign so and so, promissory note or bill of exchange so and so. It means the Indian legal tender. The power of the authority under section 16(7)(2) of the Act, where it is only books of accounts and things. And goods does not include money, and money has been defined to be Indian legal tender, my lord. The authority have no power to seize cash from in the GST proceedings. Now, this issue, my lord, came up before different high courts, my lord. And the high courts took the view that cash cannot be seized by the authorities, and directions were issued to return the amount immediately to the petitioner. SLPs were filed, and the same has also been dismissed. SLP dismiss হয়েছে যোগ করতেছে Delhi Deepak.
Yes.
Well, here you'll also find the court, first of all, dealt with the definition of the section 67 of the Act. And after dealing with, you'll also find at page 202. The court says 202 type করো না নাকি? কত আছে? কত আছে? What's goods item? Hmm? 202. At page below 290, 292, এটা কিউ করো নাই? At the bottom below, it is করো নাই? Huh? Position খুব বলুন। It says not the word goods as defined in so and so of the Act is qualified with the condition of being liable for confiscation. Thus, only
Which
those
part you are reading? 292?
20 page 202 292 na 292 last paragraph milo
Paragraph 34.
34 te nahi at the bottom below
This paragraph
34, my lord.
34. Yes.
The words goods as defined in the section so and so of the act, in which terms the said term as used in section 67 of the act is qualified with the condition that of being liable to confiscation. Thus, only those goods which are subject matter of or are suspected to be subject matter of evasion of the sanction during the course of such met under subsection 2 of section 67 of the act, the officer conducting the search may find various types of movable assets. Illustratively, in an office premises, one may find furniture, computer, communications, instruments, air conditioners, so and so of the act. Now you'll also skip over and come to mirror para 42. The second proviso, although couched as a proviso, is an integral part of section 2 of section 67 of the Act. The same clearly reflects the legislature intent of empowering seizure of a document, books of account, things is for enabling their use or aid in the proceeding under the Act. 43, my lord. Subsection 3 of section 67 of the Act, consistent with the legislative intent of permitting seizure of the books of accounts, things, provides that if the documents or books or things seized under subsection 2 are for not relied upon for the issue of a notice under the Act and rules made thereunder, the same shall be returned within a period of 30 days. Although there is no ambiguity in the language of section 2 of section 67 of the Act that seizure of the books of accounts or things is permissible only if the same are considered useful or relevant to the proceedings under the Act. Subsection 3 of the section 67 makes it amply clear that the purpose of seizure of the books of accounts or things is only for the purpose of reliance in the proceeding under the Act. It therefore posits that if the documents or things or books of accounts are not relied upon by the notice that is seized, the same are liable to be returned. Now we'll also see paragraph 47. We are unable to accept that the word things must be read expansively to include any and everything, notwithstanding that the same may not be yield or provide any material useful or relevant to any proceeding under the Act or contended by the revenue. It is necessary to bear in mind that the power of search and seizure is a drastic power. It is invasive of the rights of the taxpayer and his private space. Conferring of unguided, unbounded power of this nature would fall foul with the constitutional guarantees. It necessarily follows that such power must be read as circumscribed by the guidelines that qualify the exercise of such power and the intended purpose for which it has been granted. As stated above, it is constantly clear that the exercise of such power is restricted only in cases where, in the opinion of proper officer, seizure of the useful for the so and so act. Now, Lord, kindly see me, Lord. The last part, my lord. Last part, we can go online. That page, my lord, 298. Para 55. Possible alaya.
Now, what is the case about?
My lord,
Yes, the money that has been concluded that respondents currency and other valuable assets
my lord, the 11 lakhs rupees cash was seized
seized.
and the debit cards of the bank.
What are seized? Where is this seizure?
The amount is with the department, my lord.
No, where is the seizure?
But you'll also find at page 34.
34.
Oh, 34 I say. You'll also find this is the seizure memo. Case quote as a case. But this case quote as
Bank cards are there.
page 35, my lord.
Okay.
This is 11 lakh cash. And you'll also find the debit cards, etc. at page 40.
That is on 5/6/2025.
My lord.
Yes, Mr. Setia.
Now, my lord, my submission for loss is that, my lord, the cash so far is absolutely without jurisdiction. The debit card so far as concerned, it has no connection whatsoever with the seizure, with the evasion of the tax, GST under the Act. My lord, so far as as income tax authorities are concerned, they may go for the seizure of some things, but debit card so far as they're the bank statement will show that which transactions have been committed. Now, mobile phones, they can download the data. They can download the entire data. But 6 months, no proceedings have been initiated. No notice has been issued. And they are just sitting over it and keeping it with them. Now, if no proceedings have been initiated and nothing is there, and we made a request number of times to return it, we also requested that, my lord, you may download the data from the mobile phones and all those things, but it may be returned. That has not been done.
Yes, Mr. Shetty.
Yes, at this stage, my lord, I am praying for, my lord, some time to get instructions, lordship.
If cases cannot be retained,
My lord.
and this bank, debit cards, credit cards, whatever. You need a statement. Basically, you need the statements.
Well, SLP against this judgment was also dismissed. And another judgment of the High Court of that also the same on the same issue.
They should be given a short notice.
Lord. At this
What kind of notice?
lordship, my lord, issue notice, my lord.
Within what period?
Lordship, within 2 weeks, lord.
Well, on the issue of returning of the that notice may be given, because the question is not on the merits, they cannot keep it. So they may come up and explain, why on which power they have,
Because, my lord, this, my lord, seizure was conducted by, my lord, DGCA, my lord. My friend is appearing for DGCA, my lord.
For DGTI.
DGCA, my lord.
DG?
Director General of, my lord,
Intelligence.
that is the separate wing, lord.
Okay, that is respond number?
3 and 4, my lord.
Okay, okay.
My lord, we'll both, my lord, will file a response, my lord, within 2 weeks.
So, Dr. Saraf, regarding which of the items I have understood that cash and debit or credit cards,
my lord.
and regarding mobile phone also.
My lord. And one more, my lord. On the last item, page 40.
Heard Dr. A. Sharaf, Land Counsel for the petitioner. Senior Counsel is led by Mr. B. Sharma, Land Counsel for the petitioner. Mr. S. Setia, Senior Standing Counsel.
Lordship. I am for Amendment 2, my lord.
Miss? Standing Government Council. For the response number 1, Mr. S. Setia, Senior Standing Counsel. CGST for the respondent number 2, Mr. K. Jain, on behalf of
Lordship, Mr. Asika. Mr. Asika.
Asika and Senior Counsel and Special Counsel,
For 3 and 4.
DZ,
GI.
ZI for the respondent number 3 and 4, post of para. A proceeding was first and seizure proceeding under section 67, CGST Act was carried out in the premises of the petitioner on 4/6/56. 2025. 6/2. And at the end of the proceeding, comma, a panchnama and an order of seizure of event that were passed. So, in the course of the said proceeding, an amount of rupees 11 lakh number of bank cards, 70 number of bank cards were seized, apart from 3 mobile phones registered in the name of the petitioner.
Any pen drive?
Post of other items, including a pen drive, were also seized in the process. Post of para. It is the contention of the land senior counsel paying for the petitioner that cash, comma, and bank cards could not be seized in exercise of powers under section 67 within brackets 2 of the CGST Act as cash and bank cards do not come within the purview of the definition of goods. Moreover, comma, the respondent authorities would have retrieved all the materials, all the materials from the mobile phones of the petitioner, and there is no reason for not releasing the cash, comma, bank account, bank cards, comma, mobile phones, etc. of the petitioner, despite elapse of more than 11 months since 5/6/2025. First of, it is submitted that it has been held only goods suspected to be subject matter of evasion of tax can be seized in a proceeding under section 67(2) CGST Act, and none of the aforesaid seized items like cash, mobile phones, or bank cards mobile phones can be held to be goods to be subject matter of evasion of tax. Okay. Learned counsel for the respondents have short time to respond to the allegation of illegal retention of the seized goods, seized items from alleged by the petitioner. First of issue notice, notice is made returnable, did you? 2 weeks. Not 2 weeks. Notice is made returnable on so-and-so.
3rd June.
Issue, as so-and-so is appeared, accepted notice. Issuance of formal notice and dispense with Mr. So-and-so Sarmani. Counsel for the petitioner shall supply extra copies, requisite number of extra copies of the rate petitions to the respective counsel for the respondent within 2 working days from today. For the respondents shall ensure that their responses are filed on or before the returnable date. Post up. This order is kept in the record.
My lord. So the second case is similar, my lord. Only in
Same case.
in that
no
case only mobile phone and the debit and credit cards are there.
bank cards.
Bank cards.
Mobile phones.
Mobile.
How many mobile phones?
One mobile.
One mobile phone liquidable. And bank cards, how many? 17. Page 17.
37.
Yes, part 2, Gusari. Yes, part 2, Gusari. Huh? Same date.
Same date.
Parties are same?
Parties are different, my lord.
No, no.
Petitioner is different,
Principal-
otherwise same.
Respondents are same.
My lord.
Real numbers are same.
Lordship.
I'm highly obliged.
Goods are mentioned at page number 38, Lordship.
Silo pocket mobile phone আছে আৰু, huh?
21.
I am obliged, Lordship.
My lord, in this case, the petitioner is challenging a provisional attachment order passed by the authority under section 5(1) of the PML Act. Now, if you lordship looks into the provisions, section 3, my lord, deals with the offense of money laundering. May I read, my lord? Whoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party is actually involved in the process activity connected with the proceeds of crime, with the proceeds of crime, including the concealment, possession, acquisition or use or projecting or claiming it as untainted property shall be guilty of the offense of money laundering. Oh, my lord, it is connected with the proceeds of crime. And when the proceeds of crimes are there, then in respect of the schedule offense, my lord, the money laundering offense can be taken. Now, I will also kindly turn to my lord, section 5. It is, my lord, attachment of the property involved in money laundering, my lord. Where the director or any other person not below the rank of the deputy director authorized by the director for the purpose of this section has reason to believe, the reason for such belief to be recorded in writing on the basis of the material in his possession, that any person is in possession of the proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to the confiscation of such proceeds of crime under this chapter, he may, by an order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. So two preconditions are there, my lord. One, first, the authority must have a reason to believe, which must be recorded in writing. And secondly, there must be proceeds of crime. And thirdly, the satisfaction that such proceeds of crime are likely to be concealed, transferred, or dealt with any manner which may result in frustrating any proceedings relating to confiscation of such proceeds so and so. If these three preconditions are not fulfilled, my lord, Section 5(1) power cannot be exercised. Now, the proceeds of crime has been defined. Section 2(1)(u). Huh? 2(1)(u). Page 10 of the book.
Yes.
Proceeds of the crime means any property derived or obtained directly or indirectly by any person as a result of the criminal activity relating to a scheduled offense, or the value of such property, or where such property is taken or held outside the country, about the property equivalent to the value held with the country or so on. So it means, my lord, that any property derived or obtained directly or indirectly by any person or as a result of the criminal activity relating to the scheduled offense or the value of such property. So first of all, my lord, it must be derived or acquired in relation to a scheduled offense and the value of such property. One cannot attach a property of 5 crores when the proceeds of crimes alleged is of 50 lakhs only.
Yes.
Now, as you also be aware, the reason to believe has to be first recorded by the authority, and thereafter he can proceed for making the provisional attachment order. Now, in this case, you'll also find the provisional order attachment starts from page 187, and you'll also see the relevant part page.
This order is otherwise temporary,
Lord, this honorable court had the occasion to deal with the issue.
but Supreme Court has said.
No, Supreme Court has also said, Lord, this honorable court, after dealing with all the Supreme Court judgment, I will place the Supreme Court judgments also for our civil. The Supreme Court has said that the 5(1) power can be exercised only when the preconditions are fulfilled. The Supreme Court has also said that this is not an irregularity but an illegality. And there are various judgments I placed before Lord Similor, the judgments, including the judgment coordinate bench of this honorable court, wherein all the three issues which I am raising, my lord.
What is the point? As regards the value.
Well, my lord.
As regards the value, you state.
No, the question is that, my lord, here the authority is coming to conclusion, I will place before you, that the property which has been attached is not traceable to the proceeds of crime. 247. In the order part, my lord. After the bold, my lord, the amount has been mentioned. This is about all the other persons. This is not relevant to me only, my lord. There are various persons' property have been attached. The aforesaid immovable properties, have you also got in, my lord? After the 14 crores, something is mentioned, my lord.
Page?
Page 247. In the order, after 15 lines or something, There is a bold in something is mentioned, my lord, 14,85,000. 40 crores.
Crore. Yes,
After
14,
that, my lord,
14 crore.
my lord. After that, the aforesaid immovable properties and movable properties at para 5(1) are not directly traceable to the proceeds of crime, but represent value equivalent to the value thereof in the proceeds of the crime amounting to rupees so and so. If the property which is assessed is not traceable to the proceeds of crime, then only because the value of that property which was acquired prior to the commission of the offense, alleged offense, my lord. The property which is made attached, my lord, this was acquired prior to in the year in the year 2022, whereas the alleged schedule offense is said to have been committed in 2023-24 financial year. Now, three issues which are arising for consideration for lawsuit, my lord. First, your lawsuit will like to know, my lord, whether a writ petition under order against 5(1) will be maintainable. Second, whether when there is no proceeds of crime, property is not traceable to the proceeds of crime, and the same doesn't fall in section 2(1)(u), whether the same can be attached, whether the reason to believe which is required to be recorded prior to the order of attachment, and the same has been recorded in the provisional order.
Other the property is attached.
Only one
of the-
property, my lord.
Which property?
Property, Councillor. इसमें दिया है page 252, 236. 236. Serial number 3. Two plots of land.
Where are the sale deeds?
So same this. Annexure 9, page 252. 252. I have to place some so reason to believe कौन है देखना तो इसमें reason to believe note किया ना
When the provisional attachment order has been passed?
Well, first of all, I will show to you, Rossi, that the reason to believe was recorded in the order. Page 244. 244.
I'm asking you. This order has been passed on 30/3/2026.
My lord.
And what was the matter of inquiry, investigation?
My lord.
In the case, transaction between?
Well, the transaction, I will tell you, my lord, what is the transaction? Well, this is a GST matter, my lord. I purchased the goods from a company who is a registered dealer in existence, who submitted the return and, my lord, everything paid the taxes.
Which period was under investigation?
23-24.
23-24.
My lord.
That is the subject matter of investigation.
Now the allegation is that, my lord.
And you acquired this property in 2022.
22.
Now, according to you, this cannot be made subject matter of attachment. That is sum and substance.
No, this is not only one, my lord.
No, we are at the motion stage.
My lord. Well,
So, the subject matter of investigation in the connected case is 2023-2024, evasion of GST. And according to you, this property has been attached by the provisional order of attachment under order 5(1), section 5(1) by the authority. And this property was purchased by you in 2022,
Right.
right? So is there anything directly on the point that no such property can be attached?
I can show you. If your lordship, just before I go in that issue, may I take?
No, we'll issue short notice and we'll give you relief, provided you satisfy.
My lord, just
Because then after we'll have a detailed hearing,
certainly, my lord.
subject to Mr. Dhor's response. Because there are other matters also.
My lord, I really get an opportunity nowadays.
No, because there are other matters also in the line. Then we can have a detailed hearing,
Other, it was property purchase prior to that cannot be.
keeping the maintenance issue open. You are for?
I am for the mother. My lord, you also can see page starts from. You'll also see page 389, a division bench judgment of the Punjab Haryana High Court, my lord. You'll also make any turn to page 407.
Yes.
Para 31, my lord. May I read, my lord?
Yes.
Property purchased prior to the commission of the schedule offence, leaving aside the date of enactment PMLA, does not fall within the ambit of the first limb of the definition of the proceeds of crime. However, it certainly falls within the purview ambit of the third limb of the definition. Counsel for both the sides, you'll also may skip over the last three lines, my lord. Any property, irrespective of the date of purchase, may be attached if the property derived or obtained from the schedule offence is held or taken outside India. I will also may skip over and may come to my lord para, the in between, my lord, para 32.
Yes.
The moot question arises that whether property or equivalent value may be attached where the property derived or obtained from the schedule offence is not held or taken outside India. If any property is permitted to be held liable to be attached irrespective of date of purchase, it would amount to declaring second and third limb of the definition of proceeds of crime one and the same. As pointed out by the counsel of the opponents, the third limb of the definition clause was inserted by the act of so-and-so. The aforesaid third limb has been further amended so-and-so, enlarging the scope. The question arises that if the phrase value of the which such property and property equivalent in value held within the country or abroad are the same commutation and carry the same meaning, there was no need to insert the third limb in the definition of proceeds of crime. The amendment made by legislature cannot be meaningless or without reasons. Use of different words and insertion of third limb in the definition cannot be ignored or interpreted casually. Every word chosen by legislature deserves to be given full meaning and effect. Accordingly, words value of such property and the property equivalent value held within the country or abroad cannot be given the same meaning and effect. Had there been intense legislature to include any property in the hands of the person within the ambit of the proceeds of crime, there was no need to make three limbs of the definition of proceeds of crime. Last two conclusion are Lost in para 51, page 417. In view of the above discussion, we summarize our findings as below. Now, lordship to C2. Property acquired prior to the commission of the schedule offense, that is a criminal activity, or introduction of the PMLA cannot be attached unless property obtained or acquired from schedule offense is held or taken outside the country.
Promotional schedule offense. What is this or? Property acquired prior to commission of scheduled offense, that is criminal activity. That
My
I have
lord.
understood.
My lord.
Or introduction of PMLA.
My lord, if the introduction of the PMLA, if it was acquired,
Something has been given retrospective effect.
my lord, if the PMLA Act was acquired, my lord, enacted in the year 2012. No?
I think it has been given some retrospective effect, the amendments.
No, my lord, in the Act, it is
2002, and then it was amended in 2023.
the PMLA Act has not been, this one has not been given. Proceeds of crime will also be seen. Retrospective दिया गया. Section 2. Retrospective दिया है. यार, कौन सा किताब पकड़ा है? हमारे तो लगे ही. ये हमारे पास नहीं है. When you also see.
6.
The Act itself came into force in 2002, my lord. Well, also, if you also once again take the tribunal of definition 21Q, my lord.
Yes,
May I once again, my lord, for the sake, even for the sake of repetition, my lord. Proceeds of crime means any property derived or obtained directly or indirectly by way of by a person or so and so, and therefore you'll also see or value of such property. So the property derived or acquired.
Yes.
Pursuant to a criminal activity. And then it says or value of such property. Even if it is assumed, my lord, for the argument's sake, that the value of the such property means only value of property. If the property is not traceable to the proceeds of crime, then it cannot be said that only because the value of any property is equivalent to the amount and thereby it can be attached.
Your statement has been recorded.
Well, a statement was only recorded, my lord.
Which page?
Yes. Page 308, my lord. ये तो स्टार्ट थोड़ी होता है यार, स्टार्ट बोलो ना यार।
Summary, summary of
एलेक्स से कहाँ से स्टार्ट होगा?
ये रसो, ये रसो।
408 मिलो, 4.8। If your lordship permit me, I've just गवर्नमेंट डिपार्टमेंट सप्लाई किया ना। इसमें दिया ना। यूनिट को जो इससे किया था वो 3B का फाइनल किया, उसमें लिखा था हम लोग। इन्फेक्ट किया था 20 में किया होगी, जिस फर्स्ट सप्लाई किया हो उस पार्टी का बारे में 3B भर दिया हो। पहले 15 नहीं यार, वो जो पार्टी परचेज किया वो 3B दिया था, उसने दिया ना हम लोग।
Come to page 234.
234 में लो माइलो।
Paragraph 5.8.6.5.
मेरा 5.
8.6.5.
माइलो। Well, I may just, if you lost it before going this one.
And there were transactions running from 2022.
Submission. The allegation is not against me. There is no allegation against me. There is no allegation against the supplier of mine. The allegation is against the third party.
Right. Absolutely. This is a case of money trail.
Certainly,
PMLA is not only that person who has done the predicate offense. It is regarding also money trail.
Money trail certainly, my lord.
Yes.
But if I have not committed any offense, is it DST law, my lord? and the GST law I will show to your lordship, the offences which are there have been prescribed in section 132 of the Act. Now, when I purchase the goods from someone, he has paid the amount, I have supplied those goods purchased to the government department. Now, he is saying that the third person who supplied the goods was a fake one. Now, my lord, when I have received the goods, the person who supplied the goods, he has shown in his return, he was a registered dealer, he had paid the taxes, whatever is to be paid. But can the duty on the purchaser can at any stage verify that third or fourth line from where allegations are there that he was fake? So my lord.
It is not about criminal prosecution against you as a
Criminal
whole,
prosecution
as a
against-
whole. It is basically the entire act is based on proceeds of crime. Maybe bona fide, maybe mala fide, but they are saying, I am not saying, they are saying that money trail can be found through two sell entities to your farm
This is their allegation.
to the extent of 50 point something lakhs. And they are saying that transactions are found from financial year 2022 onwards. It is not about your criminal prosecution, maybe, but it is about the proceeds of crime which are to be recovered. Whether that is a matter which are to be
Something I will not do.
gone into.
My lord.
To be gone into.
But
And there are also provisions where you can show after receipt of a notice from the adjudicating authority that these are out, should be out. That opportunity is always available
I certainly will.
by a full
No
scale
doubt.
hearing.
No doubt, my lord.
And thereafter it can be dropped.
My lord, no doubt about it.
That opportunity, we are testing on that limited area. We are testing on a limited area. Very limited.
But I must just submit. If subject
So
to
I'm
sorry, my lord.
I'm putting
I'm sorry,
my
Absolutely, my lord.
scope of examination.
I'm sorry, my lord. Your lordship correct, my lord.
So within that limited area,
Only
something may be factual, something may be law,
My lord, absolutely.
or everything can be a law. If
Absolutely.
something factual comes up, we'll
My lord,
keep our hands off.
absolutely within a limited area, my lord, my arguments will be only on limited area. And limited area are three, my lord. I'm just praying for three areas. I know that, my lord, that factually your lordship will not go into the facts and all those things.
Whatever is alleged, as the criminal jurisprudence will come in, whatever is alleged regarding charge, this is the same principle would, I think, apply.
My lord, certainly.
I'm not conversion with PMLA laws,
My
but
lord, I will not like.
the logic is same.
Well, I will never like a lordship to go into the materials, the whatever the allegations are there and all those. I'm not going into it. I'll not take the trouble with lordship to go into it once. I am only making my submission on three grounds. One, the reason to believe, which is a precondition to the.
For that, I have to read this order.
No, I'm sure your lordship no reason to believe at least has been recorded in the order. That is, your lordship will find place.
If you, I propose we can have it at length on Tuesday if you are. It is convenient.
Your lordship may see page 244.
No, Mr. Dr. Saab, if it is convenient for you, I can have it at length on Tuesday.
I will no problem at all, my lord. Only thing is that they should not proceed further. No, my lord, no. Then let me come. Before my submission, you are saying no.
No, this Tuesday.
No,
is
is
an imminent. Is any Damocles sword is hanging till Tuesday.
my lord, just my lord, at least my lord, my learned friends will know. At least I have the my lord. I can make a prayer before lordship. No or yes will come from your lordship, my lord. It cannot come from the other side. No. One of my submission for lawsuit is that if I can prima facie satisfy your lawsuit on the basis of a judgment of this honorable court itself in the coordinate bench on the same issue, that the issue is fully covered by the judgment of this honorable court. Because you also may see at page 244, just take the table of 244, my lord. Number 7. And you also got it, my lord. Now, the issue which I am raising before lordship is that, whether recording of the regions in the provisional attachment order itself is in compliance with section 5(1) of the Act. And this honorable court has held, if your lordship just permit me, I may place that portion of the judgment. 355. Start कितने पर? It starts from page 350. And 11 portion is page 382. अरे भाई थोड़ा सा रुक जाओ ना यार. Para 41 मिलो. Page 382.
Yes.
Will also permit me, I may just read it, Milo. The relevant paragraphs, in fact, in that portion is 7 or 8 lines from the bottom, Milo. If that be so, not a illegality.
But if you read, that was in an attachment.
Milo, provisional attachment.
No,
Milo.
that is in a. The judgment says that regions to believe was recorded subsequent to the provisional attachment order.
Milo, the lordship says last part, Milo.
Where from in this case we can infer?
Milo,
Where
because the
from?
materials were placed, Milo, before the court files, and your lordship says the last part, Milo, 5 lines, 6 lines, Milo. If that be so, if that be so,
Yes.
in the condition provisional order, if that be so,
How can this order be compared?
my lord, here your lordship see the order 244. Seven regions to believe.
This is part of the attachment order.
That's why the part.
Where is the table in that order?
My lord.
Reference, paragraph 20.
My lord.
In that judgment, where is that paragraph? Table 20. Table.
Table 20 kahan hai?
Because it was on that basis it has been observed, and the court says, which was placed before the court.
Below the place before the court by the materials.
Subsequently, something has been placed.
Below-
Facts of each case are different.
Actually, my lord, I am just
Cannot-
placing, trying to place the law.
this-
My lord.
If
I'm
we read the entire paragraph,
My lord,
then you see further analysis of the reasons to believe which was placed before this court. Shows the respondent to order provisional attachment of image so and so as detailed in the table under paragraph 20 of the provisional for a period of
my
so
lord,
and so.
that's why I'm saying.
So this reason to believe has been recorded subsequently to the attachment order. That is what the court says.
My lord, if you, once again, my lord,
If
subject,
that be
my lord,
so, that is to be read in the context of the previous
my lord,
statement.
once again, if my lord, maybe my lord, I have incorrectly read.
Maybe I may be wrong, but
No, no, my lord, your lordship will.
no, I may be wrong, but I don't think,
My lord, as detailed in the table under so and so of the provisional. attachment
which
order.
was placed before the court. It is not part of the
My lord,
provisional
my lord, what I was,
attachment order.
my lord, what I was submitting.
If we can see the whole judgment, then only we can understand.
Well, certainly, my lord, your lordship is correct, my lord.
Yes, where is it that?
My lord,
Because-
in fact, your lordship.
Because it says if that be so. So that is why court has observed that reasons to believe have been recorded subsequent to the provisional
My lord,
attachment
what
order.
I was.
Yes, Mr. Sharma, you have read the judgment fully.
Yes, sir.
What is the context?
One of the context herein is that the reason has to of belief has to have a separate order into it, and this has to be separate. Whereas in this instant case, the reason of belief has been part of the provisional attachment. So that
You
is
want to
the-
say reasons to believe should be in a different
Yes, madam.
material
Prior to
Prior to
proceed.
the attachment, madam.
prior to the attachment.
Attachment. He has to derive the reasons to believe, and then only he can attach. Here he has attached, and with that he has come to reason to believe.
Well, I will just give you an example below.
If
148 Income Tax Act, your lordship has dealt with so many cases below.
Hmm?
148 of the Income Tax Act, your lordship has.
No, I have not dealt.
Well, the reason to believe has to be first recorded, and thereafter the notice can be issued. Here, my lord, the lordship said.
That if you want to say that reasons of belief cannot be a part of the attachment order.
My lord. It can.
I record that proposition, I pass an order. If it comes out to be wrong, then it will be
My lord.
serious. I record that your statement.
Certainly, my lord, your lordship will.
Then
record my submission.
yes,
And secondly, my lord, my submission, my lord, subject.
that is enough. All other contentions are left open to be asked. That all other questions and contentions are left open to be asked.
The only.
I am passing an interim order.
Sir, my lord, only one contention, my lord, that the proceeds of crime which has been said not traceable.
Though I am not satisfied.
I will try my best to
But
convince.
since it has come
My lord,
from
certainly-
Dr. Saraf, I am recording.
My lord, I am making my submissions on that basis. And second submission.
Every submission I'll take note of.
Well,
But for the purpose of interim order,
Well,
I'll record this statement.
My lord, only one submission, if your lordship pleases, my lord, that the authority itself says that it is not traceable to the proceeds of crime only on the basis of value. I am seeking it, which is not permissible in my humble submission.
I passed the interim order. All questions are left
Absolutely.
open
Well, absolutely, my lord.
and all contentions are
Well,
left to be asked.
My lord, to the
If
best,
that is the statement from Dr. Saraf,
to the best of my ability and knowledge, my lord, I will,
then let myself be equipped also.
my lord, try to
In the meantime, yes,
assist
Mr.
your
Rao.
lordship, my lord.
My lord, I will make a very brief submission, my lord.
I have not made my full submission.
Right.
My lord, I have also.
Revert that submission.
No, yes, I heard, my lord. I am also without any instruction, but still I will try to assist the court, my lord. My
Make
lord,
it short on the interim prayer.
my lord, interim prayer, my lord, this rate is not maintainable in the present form, my lord. I will start from that. My lord, why?
Why? Just short.
My lord. My lord will come to section 5 of the act. My lord has gone through it, my lord. So, my lord, basically, section 5 says that where the director or any other officer not below the rank of a deputy director authorized by the director for the purpose of this section has a reason to believe. Reason to believe, my lord, The thing is that he has to be satisfied. After going through the materials, the deputy director or director has to be satisfied that yes, there is materials and he is satisfied that it's proceeds of crime, my lord. On the basis of the material in possession that any person is in possession of any proceeds of crime, such proceeds of crime are likely to be concealed, transferred or dealt with in any manner which may result in frustrating any proceeding relating to the confiscation of such proceeds of crime. My lord, then I go to 5(2). The director or any other officer not below the rank of a deputy director shall immediately after attachment under section 1, subsection 1, forward a copy of the order along with the material in possession referred to in that subsection to the executing authority.
Mr. Lord, that is the second.
No, my lord, why I am here, my lord? Because subsection 8 has been invoked, my lord, already. That is what, my lord. Section 8, my lord. So, my lord, now my lord will come to 187, that provisional attachment order, my lord, of the writ petition, my lord, 187. 187, my lord. My lord is in 187.
Yes.
So, my lord, this is a provisional attachment order under section 5, 3326. My lord, take note of the date. It is 3326. My lord, the next page, 188. There is a table description of the documents. Serial number 1, my lord, the FIR. FIR, my lord, 182 of 224. My lord, the sections 120B, 420, 467, 468, 471, 473, 474. These are all IPC, all schedule offense in the act. Now, my lord will come to the second, and ECIR has already been, my lord, an internal document. It has been raised. Then serial number 8, the writ petitioner. Statement of such and such, my lord. So he is there. Now, my lord, I will not take much time, my lord. My lord will come to page number 191. 191, my lord. The paragraph in the bottom, my lord. Upon careful examination, my lord is there, my lord. Upon careful examination of the aforesaid information, documents, and the facts unearthed during follow-up inquiries and on consideration of the materials, evidence available on record, I am satisfied. So, my lord, the deputy director says that he is satisfied. Satisfied that there exists credible grounds to form a reason to believe that certain person in the possession of proceeds of crime as defined under section 2(1) of the Prevention of Money Laundering Act. Further, I have a reason to believe that such proceeds of crime are likely to be concealed, transferred, or dealt with in a manner which may frustrate or adversely affect the proceeding relating to the confiscation such as proceeds of crime under chapter 3. So, my lord, he has already made a decision that there is a, my lord, satisfaction that and reason to believe that there is a proceeds of crime. Now, my lord will come to page number 249 of this last page of the attachment order, my lord. 249. Why am this is the law, my lord. They have followed each and every step of the law. 249, my lord. My lord will see its copy forwarded to the information. My lord is there, my lord. Number 1, chairperson, executing authority under PLMA, my lord. So they have already forwarded this attachment order to the authority under section 8. Now, my lord, I will straight come to my lord Vijay Madan Lal. By the way, kitab kon diyo.
Issue of compilation.
Nahi, moi kitab to problem. Moi mane still in the old state. My lord, basically, section 8. Section 8, my lord, an adjudicating authority, he is an authority under the act. He is a neutral authority, my lord. This authority has the power to, my lord, go into the thing. They will get a show cause notice, my lord. And there is again embargo within 30 days. 30 days from the date of our, my lord, this sending of this, we have to file an OC, original complaint. Within the, if we cross 30 days, it will lapse. So within 30 days, we have to make, it has to get registered within 30 days. Thereafter, my lord, the adjudicating authority will send a show cause to him. They will get 180 days time now. Once we file it, 180 days we'll get 6 months. In this, within this time, adjudicating authority will send a show cause notice. This is under the statute, my lord. Then they will have a, my lord, full right to appear before the thing, authority, make their case, plead their case. It may be that, my lord, in many a times it is seen that, yes, there is no proceedings of crime, that you let it go. If adjudicating authority passes an order, my lord, against the petitioners,
That I know.
then
That much no.
appellate
Tell
authority.
new things. Section 26. That much basic things I know.
No, then, my lord, it's High Court. In
That's
a
High Court.
division
That
bench,
also.
division bench in appeal.
That I also.
Why I am on this, my lord? There, my lord, I will just read from, my lord is in a hurry. My lord will come to page 199. Vijay Madan Lal, what Supreme Court said, my lord, why this safeguard has been given?
190.
199 of the book, my lord.
Then the condition is the same which is for SCC in the compilation.
Yes.
My lord, 174, my lord. It's about the safeguard, my lord. The procedural safeguard provided in respect of the provisional attachment are effective measures to protect the interests of the person concerned who is being proceeded under the act in the following manner as rightly indicated, and that is what, my lord, the court has held. Then next, my lord. For invoking the second proviso, the director or any officer not below the rank of a director will have the first apply his mind. So my lord, he has already applied his mind. That is, we can see from the order or the attachment, my lord. Apply his mind to the material on record before recording in writing his reason to believe in certainly a sufficient safeguard to the invocation of the power under section and proviso of section 5 of the act. So, my lord, why this safeguard, my lord? So that both the party, my lord, do not get aggrieved, my lord. So there is a safeguard. That is what, my lord, Vijay Madan Lal, my lord, has held. Now, my lord will come to next page 200. 174(2). There has to be a satisfaction that if the property involved in the money laundering or proceeds of crime are attached immediately. So, my lord, we have done it immediately. Immediately, such non-attachment might frustrate the confiscation or proceeds of crime under the act. The order passed under section 5(1) of the act is only provisional in nature. The life of this provisional attachment order passed under the section 5 2002 act is only for 180 days, subject to confirmation by the independent adjudicating authority. So, my lord, this is the procedure, my lord. So now, my lord, already we have filed our OC within 30 days. 30 days. And it has been, my lord, duly registered. I have a copy, my lord, of the registration of the OC, my lord. It was registered on 30/4/2026 in New Delhi, my lord, before the authority. So, my lord, at this moment, my lord, this is a premature, my lord. He has to, my lord, go before the court. And in such case, my lord.
Have you received any notice from the adjudicating authority, Dr. Saraf?
No.
No.
He will, my lord. My lord, similar matter our court dealt, my lord.
That is why I said to both of you, let us have it on Tuesday.
My lord,
Well, one of the issue which my learned friend is raising about the maintainability of the petition, that was specifically, my lord, dealt with by this honorable court.
I'm not on it.
No, I'm
No,
on the issue.
maintainability is not the issue.
Well, of the court.
It is the entertainability which is the
Well,
issue.
that court also distinguished between maintainability and
That I have also dealt with.
Well,
And
you lost-
we are examining that.
No,
No, we are examining that, but it will require some.
my lord, I'm not finished. When my senior,
No, I'm not saying anything. I'm not.
I did not, my lord.
I'm sorry if I disturb you. You can argue.
My lord, para 11 of the judgment, my lord. My lord, it was a very contested matter, my lord. My lord, para 11, I start. Why I said this rate is not maintainable at present, my lord. I will come to whether this court should entertain also this Supreme Court has laid a judge, my lord, the guideline also for this. I have that also, my lord. Para 11, my lord, may I read?
Para 11.
Para 11, my lord. My lord, from para 12 it starts. What I'm trying to harp upon, para 12, my lord. Now let this court deal with the challenge to show cause notice dated. My lord, here in this case, already show cause notice was, my lord, issued. Show cause, second stage already started. Show cause notice dated 26/10.
Okay, we'll have it on to Tuesday.
My lord.
No notice has been received, and you are enjoying the attachment property. It is not that.
Yes, this is symbolic.
This is symbolic.
Without certain times, without symbolic.
No,
because
no,
I'm not disturbing. What has happened, my lord? Why I have to come before court? On the basis of this attachment order, they have given the press release to everyone. ED proceeding attachment order. And what has happened, my lord, my suppliers who are dealing with me, they have stopped on the.
Let us wait till Tuesday.
Tuesday, your lordship is taking up. I know nothing, but your lordship may just further proceedings, my lord. Tuesday, your lordship is taking up. I am.
Tuesday, I'll pass an interim order or the final order.
But some protection till, otherwise, what will happen?
But you are not going to be arrested.
No.
Is temporarily.
They may pass any order in 3 days, 4 days.
But how can it be?
How can it be, my lord?
My lord,
Whether the
up to Tuesday,
authority under section 5, subsection 1 can do anything other than passing that order?
My lord, you up to Tuesday only.
Because it is subject to confirmation by the adjudicating authority.
I can make a prayer only, my lord. When your lordship is taking up the matter on Tuesday, till Tuesday they should not take any action.
No, my lord. No, my lord.
That means you want to take action?
No.
That when you are saying no, that means that you are going to take action.
Learned counsel for the senior counsel for the petition.
Why was
assistant senior counsel assisted by Mr. S.P. Sharma, learned counsel for the petition. And Union of India, anybody? And Mr. Ard or learned standing counsel.
Retainer counsel, RC, my lord. Retainer counsel.
Retainer counsel. And ED, Enforcement Directorate, for the respondent number 2. I'll raise the case again in a motion column on Tuesday. Post up. Learned counsel for the parties. For some time, it is observed from there should not be any coercive action in the petition till Tuesday. In terms of the impugned order of provisional attachment dated 30/3/2026. No coercive action.
But
till Tuesday.
because my lord, my appearance was in mind, let me saying no. That
Till
means
Tuesday. Till Tuesday.
Till Tuesday, at least my satisfaction must be there. I have no.
My lord has passed an interim order in regard to my lord.
Coercive measure. No coercive measure.
My lord, what coercive measure? Now it is adjudicating authority. They will send a summon. We have nothing to do now.
Why you are then opposing?
No, my lord. Coercive measure is different thing, my lord.
Money. Tuesday will hear you.
Yes,
my lord. I have also
No issue.
supplied another.
Yes.
And I will also, my lord, the query which your lordship has raised. Oh, no. No, I will try to find out from judgment if I can find one.
Yes, I can understand. Sometimes reasons are required to be recorded in the order. And sometimes brief reasons can be recorded. And detailed reasons can be recorded in the records contemporaneously maintained. Right. So, when I put the question to Mr. Sharma, he has said something which has not
My lord,
struck my mind.
what Mr. Sharma has submitted, your lordship will not take into consideration. Because
So this is right. So that in that paragraph, it appears that reasons are placed before the court, wherefrom the court has taken the view
Exactly,
that
my lord.
order of attachment has been passed earlier and reasons to believe are recorded subsequently.
Subsequently, my lord. That was the.
I have not read that full judgment,
My lord, what I
but
try to.
you can
My lord, I
throw
can
light to it.
I can vouch for I know that
Who
case,
was
my
the
lord.
counsel? You were the counsel.
I was not the counsel, my lord, but I know the case, my lord. Justice Borua's order, my lord.
Justice,
Honorable Justice Borua's.
which was,
Devashish Borua.
I have annexed it in my compilation.
That is
So
paragraph.
don't say that you have, I have annexed in the compilation.
I am with ED, my lord, so I should at least whatever is there, my lord.
Somebody
No,
there in
I am
the
not
court.
saying that. The court has derived that observation, perhaps, that it has been placed before the court, and from there it is clear that reasons to believe are recorded subsequent to the attachment order.
Well, my friend was saying that he was in the case. My lord,
We are not going into that.
counsel,
I know.
We confine ourselves to this case.
counsel who was there in the case, they don't read the judgment so minutely. When the person who is conducting, he operates every word of the judgment, he goes through it. Because it is already there. At the time of argument, many arguments are advanced. But when the judgment is which is in the ultimately announced, then every line, every word is by the lawyer's duty is to go by every line. So whether I was there or not, that doesn't matter.
We are confining to these cases.
My efforts people to show
Sure.
that the regions recorded must be prior to the passing of the order.
Sure.
And that
Supplementary list, item 48.
I am highly obliged, not for giving Brazilian.
But to my from the time my friend told me the case has been registered for your interview.
Yes, Mr. Goswami. Yes.
No, in the statement.
It has been registered. Heard Mr. S.C. Business Learning Counsel for the petition, Mr. N. Goswami, Learning Junior Government Advocate for all the respondents. Agor Peratud of second Peratud DDO. On 13/5/2026, Mr. Goswami was requested to obtain instruction as to whether any case has been registered in terms of the direction given in the order dated 26/2/2026. Today, Mr. Goswami has submitted on instruction that the FIR lodged by the petition, in terms of the direction given by the Court of Learned Judicial Magistrate First Class Borpeta, the same has been registered as Borpeta Road Police Station case number 51/2026 under sections 109 within bracket 1 stroke 119 within bracket 1 stroke 119 within bracket 2 stroke 296 stroke 351 within bracket 3 61A 1A let us say 74 78 79 of the Bharatiya Nagarik Suraksha Honita, and the case is presently under investigation. Full stop. In view of the above position, in view of the fact that a case has been registered, the grievance raised by the petitioner in this petition is found to have been redressed.
But when case was registered, it is not mentioned in written. And it is because of your direction, my lord, immediately he had done it.
Maybe
Yes,
that is why they have not
yes.
shown that yet.
I'm still
In
today
view of the
must
same,
be,
the petition stands closed.
victim was also not examined, recorded her statement.
It has been after, that is why I asked him by Friday. Maybe yesterday it has
Yes,
been
yes.
registered.
But if they don't proceed, well, I have to come again here.
156.3.
Yes, yes, that is.
Don't come running here.
Item 49.
Yes, sir.
Yes, ma'am. I have found one judgment
Okay, you have
of Bombay High.
heard Mr. A. Bhattacharya, learned counsel for the petitioner. First paragraph. Next, third paragraph. In the Mr. Bhattacharya, sorry, a prescription is contained in sub-rule 8 of Rule 17 of the Insurance Ombudsman Rule, 2017. The fact that an award passed by the Insurance Ombudsman shall be binding on the insurer. Full stop. Mr. Bhattacharya has, however, contended that, which paragraph?
Paragraph 23.
But that is 227.
227.
This is 226.
But then the my lord, because I'm
But that proposition is, I am not satisfied. It is only judicial forum. When it is a judicial order, only 226 petition is not maintainable. But against quasi-judicial adjudication,
I'm saying it's the violation of the section 45 of the Insurance Act. I am banking on that.
no, that is examined by an authority, a statutory authority. That statutory authority, whether it is akin to quasi-judicial, I don't know.
That is what the
Not judicial, quasi-judicial may be akin to.
Yes.
But because of this particular provision, it may not be quasi-judicial also. We'll issue notice at this stage, but I am not satisfied with this observation. Anyway,
but the there are
Mr. Bhattacharya has however contended that a writ petition against an award passed by the insurance ombudsman is maintainable. Full stop. Leaving the question open, let notice be issued. The notice is made returnable on so and so. The land council for the petition shall take steps for service of notice upon the respondents by speed post within 2 working days from today.
there is an interim prayer for interim. my lord.
Oh, where is the contempt provision? He cannot enforce his own order. You talked about it. Had the sword of contempt is hanging, I could have passed it.
That's not.
19.6. For impediment, item number 22.
Yes.
Page number 6 of the IML.
Page
Bas-
number 6 of the.
Basically want to implement my lord. Response number 7.
7.
Yeah, we have taken steps, my lord, and as per the office note, service is completed upon respondent 7. my lord.
Heard Mr. S.
That's all.
Das, learned counsel for the applicant. State Bank of India, anybody? Notices are served.
Yes, my lord. There is an order of the Lawazim court.
Okay. Mr. S.S. Roy, Mr. Architect Chudri. Learned DUI as DUI for the respondent number 4. 4 and 5, and Mr. S.S. Roy, Learned Junior Advocate, Assam. Oh, no, who is 6?
6, my lord, officer in charge, police inspector.
Okay, now like. The applicant as the writ petition has preferred the connected writ petition WPC number 7359/2025. Post of opposite parties, huh? Notices upon the opposite parties. Notice on behalf of the opposite party number 1 to 3 was accepted by a learned council on 4/2/2006. Post of by order dated 4/2/2026, notice the applicant was directed to take steps for service of notice upon the opposite party number 7. Post of as per opposite party number 4, 6, and 7. Post of as per office note dated 7/5/2026. Notices are served upon the opposite party number 4, 6, and 7. Post of the instant interlocutory application is preferred, seeking implement of the following authority. 7 to লিখে দিব. As party respond number 7 in the connected writ petition. First of it is ever that the proposed party respond number 7 is the competent and responsible authority to oversee and implementing surveillance-based action and is directly connected and instrumental to the decision-making process, which resulted in the impune freezing of the petitioner's bank account. So, in view of such position made in the instant interlocutory application, the prayer for implement of opposite party number so and so as party respond number 7 in the connected writ petition is allowed. The learned counsel for the applicant writ petitioner shall file an amended cost title before the registry within 3 working days from today. On submission of such amended cost title, the registry shall carry out the necessary correction in the cost title of the connected writ petition as well as in the CIS. Post of in view of the order passed today in the interlocutory application ISC number 215/2026, is the case on so and so. Finally, during 3 days, is the case on so and so.
But any
number yes, does.
But any date in the connected writ petition, any date.
1st June.
Hello.
Item 23.
The IA has been filed for impeding as a response number 3 and 4 in place of the. So in the meantime, what happened also, a order has been passed on 19/5/2026. Order has been.
Yes, Mr. Chetri, sorry.
Yes, the order has been.
This is for what? Implement of district commissioner in contempt case. Okay, what happened?
In the meantime, the order has been complied with as per the order. So
main contempt petition.
So the contempt.
Mr. A. Chetri, learned counsel for the petitioner, has submitted that during the pendency of the contempt petition, the order against which the contempt petition was preferred, has since been complied with by an order dated
Order dated 19/5/2026.
19/5/2026. Post of. In view of such development, Mr. Chetri has submitted that the contempt petition can be closed He has placed a copy, you want, please, he has placed a copy of the order dated so and so. Pustak, comma, which is to be kept with the case record. Pustak. This contempt petition is accordingly closed. Pustak, para, in the IA. In view of the order passed today in the contempt petition number so and so, the instant interlocutory application is accordingly closed.
Item number 24.
Some personal urgency, my senior could not be present today, Lordship. Lordship, may kindly adjourn the matter today.
Yes.
Otherwise, there is a order of Honorable Court dated 24/11/25. In fact, we have said that the land is not required for us
Yes.
because the road is complete.
Then
Lordship will be placing some documents
they are to
that
take
that
the
even the highway goes within the close proximity of the structure. Lordship, we are still liable for compensation, Lordship. We'll be placing that document on the next day.
on the request of Mr.
A. Goswami.
A. Goswami, learned counsel for the petition. The to release the case after 2 weeks. Release the case on so and so, Mr. D. Nath. And it's you are appearing as
Appearing for all.
and it's,
Except National Highway. I'm just indicating.
Mr. Senior Government
Or 5, 6, 7, and 8.
some for the respond number 528.
RP Talukdar for NHMC.
Parquet Allocator, Land Standing Officer and HAI. NHIDCL for the respond number 4.
4.
SS Royal and Central Government Council for the respond number 1 are present.
3rd June. Item number 25.
Maybe Lordship. In this case, my lord, the land, my lord, was acquired by the, my lord, authority. The land was in the name of the petitioner's father, my lord. That land was acquired, my lord. And when the, my lord, authority tried to, my lord, provide.
You want to say your sisters, brother, all have cheated you, is it not?
That is there, my
That
lord.
is your case.
That is there. But,
That
my
day
lord,
came now on 11th.
but that authority has no jurisdiction. Authority has
Let me
no-
see what your conduct.
Yes.
Then only you'll. It means a dear lordship. Where is his statement? His statement is not there, but other statements are, he is also present in the hearing also. That is what circle officer says. He's present, he had not given any statement. His brother and complaint is there. His petition was there. Mr. Ahmed.
My lord.
What can be gathered? There is a speaking order.
My lord.
That speaking order by the
Circle of
Kala or
Kala.
Additional Deputy Commissioner.
Yes. Authorized officer.
Land Acquisition Officer.
Yes.
First, he get the matter inquired through the circle officer. Circle officer submitted a report. Before submitting the report, he had conducted a hearing. In the hearing, you, your brother,
Sisters,
all your sisters were present. Sisters gave in writing.
yes.
Circle officer reported that you verbally submitted that you had no objection because, and the land was not in your possession also. Right?
Yes.
And wait, what is recorded, what is in record, I am saying.
My lord.
Thereafter, he prepared the report accordingly and was sent to the Additional District Commissioner. Additional District Commissioner considered that report and from the report, he came to a finding that Rekat Ali was in possession of the disputed land. Plus, he also had the ownership. During the hearing, he also held a hearing. Additional Deputy Commissioner. You submitted a complaint. But you did not submit any objection in writing or writing?
No, in writing, only the petition was there.
Huh?
Only the petition.
Complaint
Petition is there.
Let us see your complaint petition.
Yes.
Clear report of the circle officer. এই দাগত হজরত আলীর, ইউর হজরত আলী,
Yes.
কোনো দিনে দখল নাছিল লাটমণ্ডলৰ প্ৰতিবেদনত উল্লেখ কৰিছে. And villagers also said, right?
My lord.
Then your complaint. Danish Sikh Financial. Circle officer has issued landholding certificate in Rekat Ali's favor. Rekat Ali submitted an indemnity bond also. Record was in the name of your father.
Yes.
In another plot of land, perhaps both of your names were there.
Yes.
In this plot, father's name is there.
Huh.
Land is in the name of father,
And-
not in the name of Rekat Ali.
There was some family settlement. There was some family settlement. You have been given a lot of money.
So the plot was in the name of your father.
Father, yes.
So by way of inheritance and because your sisters had given up their right, so it would devolve upon you and your brother.
Yes.
But fact of the matter is that there is a finding that your brother was in possession. He was never in possession. You were never in possession. 30, 40 years, your brother is in possession. So in that situation, money has been released, right? Now, what is the remedy in such a situation?
Money has been released. What is the
In
purpose of that
we are
case?
not here for executing and recovery. Don't make us recovery court. Money recovery court. He has given reasoning, he has given a finding. Now, what is the remedy available to you?
Civil court is bar, man. As per Act, civil court is bar. The ADC has no jurisdiction to came in finding, man. As per Act, my lord. That he has no jurisdiction, my lord. To came up with that finding, my lord. 2013 Act. Act 175 onwards, my lord.
What is the equivalent provision of section 18? Any idea?
Equivalent reference, that is reference, my lord.
Firstly, let us see who.
64, 64, man, 64.
64. Let us go to the first part.
64, man. May I read, man. Any person interested who has not accepted the award may, by written application to the collector, require that the matter may be referred to the.
Page 60.
64? 64, man. Reference to the authority.
Yes.
Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the authority as the case may be, whether his objection be to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of rehabilitation and the resettlement under chapter 5 and 6 of and or the aforementioned.
There are four things. Measurement of the land, which is not in question. The amount of the compensation is also not. That is also not the question.
Not dispute.
The person to whom it is payable.
Is it
right?
income? Yes. As well as.
But the precondition is that any person interested who has not accepted the award. Precondition is that.
Who has not accepted?
Who has not accepted. Have you understood?
Yes, I understood.
To raise objection before the authority as the person to whom it is payable.
As well as the aforementioned of the compensation among the person interested. And regarding aforementioned, there is a provision.
Before that, what is the award? What is the award?
70.
Section?
70, Lordship.
7.
70.
70.
70.
Form of award.
Every award under this chapter shall be in writing.
70. Reference to the authority 70. Form of award. No. No, before that. 28. Section 37. মানে award given দিয়াটো when the award become final. Section 64 is to make reference to the
Yes.
authority.
Thereafter, kindly see section 75. 75, 76, and 77.
The question of apportionment doesn't only he is the claimant at that point of time. You are not there when award is done. And suppose 76,
Yes.
he has not referred
Yes.
such a dispute regarding to whom the amount is payable.
Yes.
He has decided it. He has decided it and disbursed it.
Yes.
In that situation, that by passing an order, speaking order on 11/11/2022, right? Then I am denying the claim of Hazrat Ali.
Yes.
And what would be the remedy?
Petitioner.
Because it is May.
Then 77, my lord.
Page 76.
No, my lord, 77.
No, 76.
Section 77.
Section 76.
Yes.
May.
When the amount of commission has been sent.
It is not mandatory for him. May refer.
Yes.
May refer. He may decide also.
Yes.
May not refer.
Under what authority he will decide? The act does not provide the.
No, it is not there, Mr. Ahmed. You satisfy me.
Yes.
He says may refer, it says may
Yes, may
refer the such dispute to the authority. At the same time, it can be referred, he may not refer.
But
in that case, what will be a remedy? He has decided the case himself. It is not that he lacks the jurisdiction.
He has the jurisdiction. And the speaking order is also not in.
But Act does not provide that jurisdiction to the my lord, ADC, my lord.
After hearing you, he has passed an order.
Under what supervision?
Then I am deciding, I am asking you politely the question.
Analysis section 77, my lord.
Not required. First, you have to travel through 76. 77 comes after 76.
Yes, yes.
77 does not come before 76.
Yes. But 76 shall be.
I have asked the question simply.
That I understand.
You have to understand, you have to give the answer.
Yes.
And the order has been passed as far back in 2022.
I also came immediately after my lord. This
No, whether this is the proper, because first you tell me that this order cannot be passed by the deputy commissioner because of the word may. It is not shall.
Yeah.
So normal understanding is he may decide or he may not decide. If he does not decide, he has to refer it to the authority. 76.
But
So he decided.
decided.
And it is not that it is the proceeding is unknown to you. You have appeared before the circle officer as well as the district commissioner.
Yes.
Right. And this order has been passed to all concerned. Copies. Copies.
Yeah.
Now, have you received the copies?
No, that copy I have not received. Award, the.
Award on speaking order 11/11/2020.
I have, no.
Huh?
Speaking order is not.
There is an endorsement that sent copy to all of them.
No.
Your signature appears.
Yes, I appeared in the hearing, my lord.
Then?
But section, my lord, 76 should be read with section 64, my lord. And section 63 is the bar, my lord. The issue of civil code is barred. So petitioner will be remedial, my lord.
No.
In that case.
I don't think so. Think it over.
Section 63.
That
my lord.
commission, please think it over. That court is barred. Where is the barring section?
Section 63, my lord.
Think it over. This 76, 73 has created a bar for you now to approach the civil court prior to that. For recovery, because he has issued, he has executed indemnity bond to recover, to refund the amount to the land acquisition officer if situation comes for recovery. So all these have been executed by the land acquisition officer, execution of indemnity bond. So in that situation, whether civil court jurisdiction is barred, taking interest.
But
Go through it.
Yes, petitioner can.
Go through it.
Yes, ma'am. Petitioner can file an application.
Show that by virtue of section 76, land acquisition officer lacks jurisdiction. Land acquisition officer, because of section 76,
Yes, ma'am.
he lacks the jurisdiction. Show us, satisfy us. We'll set aside this order,
Yes, ma'am.
but will not be able to make recovery. We can ask him to take face hearing, and on the basis of indemnity bond, he can proceed further. But show us that because of 76, he lacks jurisdiction. May shall be read as shall. I don't think so. So show us, I am giving you time. Have you understood? H, please reproduce it on the next date. Had Mr. H. Das done it, H.R. Ahmed, learned counsel for the petition, Mr. S.S. Roy, learned junior government advocate, Assam for the state respondents, post of Mr. Roy, on the basis of the records of the proceedings, has submitted that before the circle officer, just hand it over. Before the circle officer, Koiga Revenue Circle, the petitioner and the respondent number 6 were called for hearing apart from their sisters in the hearing, all the sons and daughters of late Danes Ali appeared and had submitted, in unison, that no, after conducting a hearing, the circle officer, Soigaon Revenue Circle, submitted a report on 20/07/2022 before the additional Deputy Commissioner Kamrup Amingaon. So in the report, it was mentioned that during the hearing, the petitioner, the respondent number 6, as well as the 3 daughters of late Danes Ali, that is the sisters of the petitioner and the respondent number 6, had submitted in unison, either in writing or orally, that they would have no objection if I am submit in unison that other than the respondent number 6, the other 5 successors in interest of late Danes Ali had no interest in the subject land, as the subject land by way of inheritance had devolved upon the respondent number 6. The report further mentioned that at no point of time the petitioner had any position over the subject land, and the said fact was found during inquiry by the Latmondal, and it was recorded in the report of the Latmondal also. Para. After receipt of the report dated 20/07/2022 from the Circle Officer, Soigaon Revenue Circle, the Additional Deputy Commissioner Kamrup Amingaon conducted a hearing by putting the petitioner, the respondent number 6, and all the 3 sisters, all the 3 daughters of late Danes Ali on notice. In the hearing conducted before the Additional Deputy Commissioner Kamrup Amingaon, all of them appeared. The hearing was conducted on the basis of a complaint submitted by the petitioner, staking his claim in the compensation amount assessed for the subject line on 15/7/2022. After the hearing, the daughters of late Danes Ali, 3 daughters, the 3 daughters of Danes Ali, submitted in similar lines as mentioned in their previous statements made before the Circle of Soigaon Revenue Circle, and had affirmed that the subject land has been in possession and ownership of the respondent number 6 since the lifetime of their expired father, late Danes Ali. Full stop. The petitioner also attended the hearing before the additional deputy commissioner so and so on 10/11/2022 with others. Post of. But the petitioner did not submit any further oral complaint or any document in support of his submission for claim for a share in the compensation amount. Post of para. A speaking order came to be passed by the additional deputy commissioner Kamrup Aminga on 11/11/2022, rejecting the claim of the petitioner and affirming the claim of the respondent number 6 to receive the assessed compensation amount. Post of para. In the Mr. Amit, learned counsel for the petition, has sought for an accommodation to make submission that under section 76 of the Right to Fair Compensation So and So Act, the collector does not have any authority and jurisdiction to decide on the persons to whom the assessed compensation amount is to be paid, are to be paid. And he must have to refer any dispute to the authority and constituted under section 64 of the 2013 Post of Law. The prayer is allowed, is that case also. Now facts are recorded. Give it, this, maybe. Give it.
On Thursday, matter may part or my lord.
No part. Let's see. I have recorded, the other court will have the benefit.
Maybe first week of June.
First week of June. 3rd June. Item 26.
Lordship. In this case, Lordship, Youngest Counsel Mr. K. Islam is out of station for medical purpose, Lordship.
What is the case about?
Case about Lordship, I think.
Execution.
Lordship. Even we have filed an affidavit.
What is there in the affidavit?
It is admitted fact that the one accident was
As a record on Saturday, lodging affair.
on 5/5/18. It is admitted by the SP.
Dispose of directing the.
Yes, Lordship.
Yes.
Heard Mr.
Alim Sheikh, Lordship.
Alim Sheikh, learned counsel for the petitioner. And Mr. H.K. Hazarika, learned junior advocate Assam Patel, fund number 1, 4 and 5. Mr. Aforesaid, learned standing also Revenue Department for the responsible to finance anybody.
Lordship, I am appear on 6 and 7 also.
6 and 7 also. Para. You are saying similar order explicit. The instant repetition is prepared by the petitioner seeking ex gratia relief in terms of a notification dated 15/11/2024 or 2014 of the Revenue and Disaster Management Department, Government of Assam. Full stop. The case projected by the petitioner, in brief, is that the petitioner's husband, late Abu Sama Ali, alias Abu Sama SK, while proceeding on foot by the, oh no, while proceeding towards his residence at Tukura from Meghalaya by riding a motorcycle bearing registration number AS-18E 1073, comma, a pickup van bearing.
Regarding the entitlement, there is a judgment against him. WPC 270023, passed by the Honorable Justice K.R. Surana, whereby it says that when the vehicle is identified, they can seek remedy under MV Act. Therefore, they are not entitled to ex gratia. Here, the FIR itself at page 18 indicates the vehicle number.
Show us the judgment. Did you file any MSC case?
Yes.
Show us the judgment. Was it in appeal?
No.
No.
It was appeal was preferred, but during pendency of the appeal, department paid him the amount. So it became infructuous. But then the legal issue still survives. That's when it's binding.
He was knocked over by a pickup van bearing registration number AS-18/C-3100, who from the backside in a rash and negligent manner. Full stop. As regards the incident, comma, the petitioner lodged an FIR before the officer in charge, Krishna Police Station, on 5/5/2018, and the said FIR was registered as Krishna Police Station case number 115/2018 under sections 279/304A, IPC. Post office. And the instant case, the respondent number 6 has filed an affidavit in opposition, wherein it is stated on the basis of records that on 5/5/2018, at about 8 p.m. on 12/4/2018, Abu Sama was coming from Meghalaya towards his home, riding a motorcycle bearing registration number AS-18E 1073, and he met with an accident at Paikan. Post of Abu Sama was immediately shifted to Life Care Hospital at Gwalpara, but on 15/4/2018, he succumbed to his injuries. Post of after receiving the FIR, the case was registered as Krishna Police Station case number 115/2018 under sections 279/304A IPC. And after investigation, the case has been surseated under section 279/304A IPC. At this stage, Mr. Aforesaid, learn it. Standing Counsel, Revenue Department has submitted that it has been held by court in advance that when the offending vehicle is identified, the relief of ex gratia in terms of the notification dated 14/11 or 15/11. What is the date of the notification?
15/11/14.
15/11/2014. Is not is not extendable. Full stop. And recourse available to such a victim is under the provisions of the Motor Vehicles Act 1988 as amended. Which part?
Paragraph 13 onwards when.
Yes, it is. Some Supreme Court judgment has been relied.
Yes.
Which one?
In paragraph 9, Shashi Sharma.
What does it say?
It says that double benefit for the same thing cannot be granted.
That is with regard to a different context.
Yes.
Right
but
from.
Yes. But then the
But,
principle of that judgment has been applied.
Has been brought in.
Yes.
But perhaps had the coordinate bench referred to the previous judgment of Honorable Justice Ujjwal Bhuiyan?
Yes.
Huh? Where it is?
That is being discussed also.
Which one?
In the later part of the judgment.
Because if I remember correctly, there it was held that this policy has been framed by the state government to provide immediate succor and relief to the family of the victim.
Yes.
And notwithstanding this relief, the petitioner, victim, it is open for the petitioner to claim relief under the Motor Vehicle Act.
But then the scheme of
if that is, I have understood, sir, this concept. This concept I have understood that there are many prior decisions before Shashi Sharma.
Yes.
Right. Patricia something and lots of cases.
Yes.
if you get the money from the employer, or get the money from life insurance benefits, then that money is to be taken into consideration while awarding compensation. And Honorable Justice Bhuya has said that ex gratia means what is ex gratia? That concept has been explained. And this is different than the statutory relief under, perhaps, if I remember correctly, if that is so, if that has been discussed, then this will be par incurium.
That's Sujit Nandi.
I don't know, Justice Ujjwal Bhuya had a long judgment.
Yes.
Where ex gratia concept has been explained and interpreted. And there I think Ujjwal Bhuya if that has been interpreted and that is not discussed, then this is also par incurium.
Minded.
Yes, Lord.
Thereafter in 2023, you have changed the policy. That is a different matter.
That's a different.
That is a different matter. Show us the judgment of Honorable Justice Bhuya also. Then we'll hold by that because that concept is not explained here. This judgment, Sosi Sharma, perhaps, is in a different context altogether because it says
In Shashi Sharma, the
employer.
Yes, yes. Dependent.
There are
were
many
having-
other judgments.
Yes.
Many other judgments. This is last in the line of such judgment. Some Christian name.
Sebastiani Lacra.
No, Supreme Court.
Yes, Sebastiani Lacra. That is
prior
the
to that also.
distinguished. Lordship may kindly post it in some other day. I'll come up
Wednesday you
with-
put it,
Yes.
get the judgment of Honorable Justice Bhuya.
Yes, yes.
We'll say,
Fine.
if this has not been discussed, then it will be par incurium.
Fine.
We'll go by the previous judgment.
Fine.
Law says that we have to go by previous.
Fine.
List the case on Wednesday for consideration. Get hold, right?
2005. Item 27.
Please, Your Lordship.
Lordship, we have received instruction also.
Something it was rejected. Something was rejected.
Yes, my application was rejected. Then I filed appeal, Lordship.
What kind of application was it?
We applied for land sale permission, Lordship. That was rejected. Then we,
Then that was rejected when?
without showing.
When?
Lordship. Lordship, may kindly find track details report to page 29.
Just 29.
Rejected on
23rd floor.
8/3/2024.
That was by speaking order. It said that case 41, that authority had already rejected your application. And you can approach him. You filed an application.
Then we
You
filed.
filed an application.
No, Lordship. Earlier we filed appeal. We filed appeal. They were sitting over the appeal. Then we approached this honorable court. This is second round of litigation, Lordship. Then we approached this honorable court. This honorable court directed to pass an speaking order within 60 days. They did not do so.
Come to page 42.
Lordship.
You approached him, then this court directed to consider the case of the petitioner.
Yes.
And to pass appropriate order. But ADC has concurrent power. He had already dismissed it. So he cannot execute. Then he says that petitioner is at liberty to approach the undersigned if he will agree by the order.
Then we filed page 43, Lord.
Page 43. Okay, on 34. You have placed it.
The direction of this honorable court.
Composite land sale transfer. Composite land sale transfer. What is the order of the High Court?
Page 35, Lordship.
What is the service you asked for?
I am seeking a NOC for sale permission, Lordship.
No objection certificate. Section 21A.
21A, Lordship.
Section 21A. On registration. Mr. Hazarika,
Lordship.
is this the order?
Yes, Lordship.
So, kindly come the page number 4, Lordship, of our instruction. Serial number 6, Lordship.
As to why the NOC was not issued by the respondent authority, Lordship. As to why the NOC was not issued by the respondent authority.
As to why?
Yes, Lordship.
What is the reason?
Yet it is clearly mentioned that the co-porter has not given their consent. Therefore, the NOC is not issued by the.
Is it?
Yes, Lordship.
Where it is?
Serial number 6, Lordship. In page 4 of my instruction.
New instruction?
Yes, Lordship.
Is it the reason?
Yes, Lordship.
Huh?
Yes, Lordship.
If consent of recorded tenant.
Yes, Lordship.
Recorded tenant means?
Single butter landlord.
I have typed instruction, Lordship. So,
So according to you, this is the order?
No, Lordship.
That cannot be an order.
It is clearly mentioned, Lordship. Even, Lordship, the Jamabandi copy is not annexed in the writ petition, Lordship.
Not required. He has to pass a
Lordship.
petitioner's grievance is that he has filed an application or she has filed an application under section 21A of the Registration Act. And that Registration Act 21A proviso says, in case no objection certificate is not issued, a speaking order with reasons thereof shall be issued.
Lordship.
So this is not a speaking order.
Not, Lordship. It is not a speaking order, Lordship.
So how can it be? His reason is that ADC has rejected it as circle officer had not recommended.
Lordship, one opportunity to be granted. I will take the instruction, Lordship.
What instruction? Nothing. We have additional deputy commissioner himself is writing.
Yes, Lordship.
We set aside the order, non-speaking order. Heard, Mr. Learned counsel for the petitioner. Mr. A. Bhattacharya, learned standing counsel revenue department for the respondent number 1, H.K. Hazarika, learned junior government advocate for the respondent number 225. Post of para. The case projected by the petitioner in this petition, in brief, is that the petitioner sees the absolute owner of a plot of land measuring 3 bighas, 1 katha, 2 lessa, covered by dag number 413 and patta number 180, situated at village number 1, Horathal, Moja, Poschim, Borketri, Police Station, Mukalma, District, Nalbari, Assam, subject 1. First up. As the petitioner had intended to purchase another plot of land for her convenience, and for the said purpose, she was in need of money, the petitioner had offered to sell the subject plot and to propose purchasers accepted the offer. Full stop. An agreement for sale of land was executed to that effect on 1/10/2023. Thereafter, full stop. Thereafter, the petitioner filed an application on 23/1/2024 before the in the designated portal seeking on 23/1/2024
Lordship.
seeking the notified public service, comma, quote unquote, composite land sale transfer. Full stop. To us, no? When despite elapse of time. Okay. Why you approached earlier?
Because Lordship, the application not rejected, Lordship, as per.
Okay.
Without showing any ground.
When composition so and so stroke no objection certificate. First of all, when no objection certificate was not issued for a sufficient period of time, nor any speaking order was passed as required under section 21A of the Registration Act 1908.
Before that, we approached the Honorable Court.
Huh?
Before that, we approached this Honorable Court. First, they rejected our application. Then we approached this Honorable Court. This Honorable Court directed the respondent to pass speaking order.
Okay.
Thereafter, we filed.
Okay. The said application for NOC was shown rejected in the designated, on 8/3/2024 in the designated Seva Setu portal, post of aggrieved by such rejection of the application, the petitioner approached this court by a writ petition WPC number 6329/2024, wherein it was highlighted that in view of the provisions contained in section 21A of the Registration Act comma, as amended by the registration within bracket Assam Amendment bracket close Act 2009. Either the NOC is to be issued or a speaking order is to be passed
Within 60 days.
within the stipulated period. First off, the repetition WBC number so and so was disposed of by an order dated 2024 with an observation that observing that an application, since an application had already been was disposed of by an order dated so and so. In the order, comma, it was order dated 2024. It was observed that the petitioner, since the petitioner had already filed an application before the District Commissioner Nalbari seeking NOC, and the same was duly received, comma, it would be apposite to the District Commissioner Nalbari to consider the claim of the petitioner and to pass an appropriate order as required, to pass a speaking order as required under Section 21 of the Registration Act, comma, as amended. Full stop. The petition was thereby disposed of with a direction to pass the speaking order within a period of 60 days from the date of receipt of a certified copy of the order. Full stop. Para. Thereafter, comma, para. A speaking order came to be passed by the District Commissioner. His response number?
Respondent number 2, Lord.
Response number 3. On
2, Lordship. Respondent 2.
2.
DC, Lordship.
2. On 11/4/2025. Disposing of the matter in the speaking order, it was observed that the petitioner had mistakenly claimed that her application was rejected by the authority without any reason. Full stop. The said observation was made for the reason that upon reviewing the tracking status of the application in the Sevaswati portal, it was found that the application was rejected by the additional deputy commissioner on the basis of non-recommendation by the concerned circle officer for issuance of the NOC. Full stop. Aggrieved by the speaking order so passed, the petition has approached this court by the instant writ petition. Full stop. Para. Mr. Hazarika Lanet, a junior government advocate appearing for the respondent number so and so, has submitted on the basis of instruction received from the office of the respondent number 2, white letter number so and so, dated 1/5/2026, that the application of the petitioner for NOC was rejected by the additional deputy commissioner, Nalbari, on 23/04/2024 as the circle officer, Borketri Revenue Circle, Mukalmua, did not recommend for issuance of no objection certificate. First off, he has further submitted that one of the in the land records assistant report, it was mentioned that there was no consent of a recorded tenant. First off, paragraph 5, me to order. The impugn order, the impugn speaking order had only recorded that the petitioner had mistakenly claimed that her application was rejected by the additional deputy commissioner without any reason. Full stop. In the speaking order, the respondent number 2 has observed that upon reviewing the tracking status of the application on the Seva Setu portal, it was found that the application was rejected by the additional deputy commissioner on the basis of non-recommendation by the concerned circle officer for issuance of no objection certificate. And it was on that basis, the speaking order dated 8/4/2025 was passed. First off, by the order dated 20/12/2024 passed in the writ petition WPC number 6329/2024, this court had directed the district commissioner, Nalbari, to pass a speaking order on the application filed by the petitioner for NOC on 2/9/2024. Paragraph 5. Whereas subsequently also, the said fact has been reiterated in the instruction placed by Mr. Hazarika Lane Government Advocate on the basis of office letter dated 1/5/2026 of the Deputy Commissioner Nalbari. Post of. Where the impugn speaking order. No, the order dated neither the order dated 23/4/2024 passed by the additional deputy commissioner, nor the speaking order dated 11/4/2025 can be termed, by any stretch, as a speaking order. First off. Both the orders have only indicated that the application of the petitioner was rejected as the circle officer, Borkhetri Revenue Circle, Mukarma, did not recommend for issuance of the NOC stroke sale permission. First, it cannot be denied that the rejection of an application for NOC stroke sale permission from the end of a proposed seller, applicant, or proposed purchaser, thus applicant would likely to bring consequences to them. First of, thus the applicant whose application for NOC stroke sale permission gets rejected, that too without recording in a region, at least has the right to know the grounds on which his stroke her application has been rejected, so that he she can submit a fresh application with all the supporting documents and requisite details stroke information, comma, meeting the deficiencies which occurred at the time of the previous application. Full stop. Speaking order paragraph of na. First paragraph 10, paragraph 11, and paragraph 12, paragraph 13, paragraph 13. Last one, a copy of this order is to be furnished to Mr. Mr. Hazarika, and Junior Ground Advocate, so as to communicate it to the respondent number 2 forthwith. If RE to paragraph 25.
If I have to file application.
No. Pass a fresh order. He has to communicate. He has to communicate it to the respondent number 2.
The time frame may be given, Lordship.
It is there.
And Lordship, I have collected one order passed by your Lordship about speaking order. What is speaking order? That is also there.
Item 28.
Yes, sir.
Lord, due to electrocution date.
Electrocution date.
Yes, my lord.
Yes, a PDCL. You want to file any affidavit?
No, my lord,
No.
government has filed the affidavit, electrical inspector report.
That cannot be a ground
My lord,
for the death of a 9-year-old child.
yes, my lord. But no
This-
fault in our part, my lord.
It is not for him to challenge this. He is a 9-year-old or what?
Yes, my lord.
9-year-old.
Yes, man, there was an art feeling, my lord.
Whatever. But his father was the landowner.
No, my
No,
lord.
no,
No.
we have not been informed, my lord. But the regulation says that we.
Whatever, 9 years. Where is your duty? This electricity advisor seems to have
My lord,
ignored many provisions perhaps. It is also your duty.
it's okay, my lord, let them, I'll file an affidavit in that case.
File it is possible, file, otherwise heard Mr.
B,
Yes,
das,
yes, you are.
S.U. Ahmed, learned counsel for the petitioner, and Mr.
B, das,
B. Das, learned standing counsel APDCL for the respondent number,
for the respondent number 2, 3, 6, 7, and 8, my lord.
and Mr. H.K. Hazarika, learned Junior Government Advocate for the respondent number 1, 4, and 5. 4
And 5.
and 5, full stop. An affidavit in opposition on behalf of the respondent, an affidavit on behalf of the respondent of 4 has already been filed, full stop. The respondent authorities in the APCL are granted 3 weeks time to complete their instruction and to file the counter affidavit. Release the case on Swens.
10 June, 10/6. Item 29.
May it please your lordship. When we file an interlocutory application, my lord, praying for impediment.
I will file objection, my lord.
What is it? What is the ground?
Well,
Aye. How you are necessary party?
well, so far as the writ petition is concerned, he is praying for that wasteland should be considered and he should be granted for building a college, etc. So far as we are concerned, we say we have submitted application, my lordship. Also,
Yes.
for allotment of that land as a grazing land. Now, so far as the law is concerned, there are 2 different provisions of settlement of wasteland or for grazing land. So, since it's the same parcel of land and 2 applications are there, therefore, what I'm praying is that the authorities consider together, proceed one way or the other. I'm not negating his prayer, but if this writ petition goes without my.
But then what
That's all.
objection you have? Let us implead it.
My lordship.
There heard Mr. S. Morning, Senior Counsel, stated by Mr. A.B.T. Hoff, Learned Counsel for the applicant. Mr. H.R. Ahmed, learned counsel for the opposite party number 1 and 2, that's petitioners. Higher education, anybody? Miss P.R. Mohanto, learned standing of the higher education department for the respondent number, opposite party number 3 and 4. Aforesaid 5 and 6. SK Hazarika. 7, 8, and 9. The instant interlocutory application is preferred by the applicant seeking its increment as party respondent number
8.
8. In the accompanying petition, WPC number 663 2026 posted. The opposite party number 1 and 2 as the petitioners have preferred the accompanying petition seeking inter alia direction to the state respondents to settle a plot of land measuring 17 bighas covered by dark number 8 and 9. Sheet number or
150, that is mentioned in the ballot proposal.
sheet number?
Yes.
Okay. And sheet number 150, Moja Ira Gold, West Land Grant. Already Westland?
My lordship.
Already Westland?
Yes, West, 150 Westland.
Nilam Bazar Revenue Site, Sivumi District, Sivumi Assam subject of post of. The petition, the applicant has averred that it is a non-registered, non-government organization, NGO. And it has also submitted an application for reserving the subject land as a grazing land. And as such, it is a necessary party for consideration of the claim of the opposite parties number 1 and 2, that's it, petitioner in the accompanying petition. So having regard to such projection made on behalf of the applicant, this court is of the view that applicant is a necessary party in the accompanying petition in view of the competing claims of the opposite party number 1 and 2, that's petitioner and the applicant for the subject land. Accordingly, the instant interlocutory application stands allowed. Mr. Ahmed, learned counsel for the petitioner shall file an amended cross title in terms of the notification dated so and so within a period of 3 days from today before the registry, and on submission of the such amended cross title by within 3 working days from today. Within so and so. HR Ahmed petitioner. Higher education, 1, 2, revenue, 3, 4, Ajurika, 5, 6, and 7. In view of the order passed today in the interlocutory application, ISC number so and so, list the case on so and so.
1st June, wait, 1/6.
After June, with my affidavit is gone for vetting. I file it. There is no bar. I prefer
8 June, 8. Wait for me.
I prefer some time, Lordship. My affidavit is gone for vetting.
Okay, Mr. You are appealing for Mr. Roy?
I'm for the state, Lordship.
Item 30. The learned counsel for the petitioners is present, Mr. S.S. Roy, learned junior government, and Mr. Aforesaid, Revenue 1. Mr. S.S. Roy, learned junior government, appearing for the respondent number 2 to 5 has sought for it. How much time?
2 weeks, Lordship.
3 weeks time to file counter affidavit on behalf of the state respondents. Release the case on so and so.
Deeply obliged, Lordship.
Item 31.
The petitioner is challenging the imposition of penalty, my lord, under section 73. The lordship was pleased to issue notice. And the interim, my lord, no corrective measure was taken. But my learned friend is raising question of maintainability. But affidavit has not been filed. If my learned friend.
Maintainability, meaning there is alternative forum.
Yes. According to me, there is no forum, but my learned
No
friend-
forum.
No forum. Railway Claims Tribunal, my lord, has been constituted for the purpose of refund of the claim. We are not seeking a refund, my lord, from the tribunal. I will place decision of Honorable Apex Court also for filing complaint before my lord Railway Claims Tribunal under section 13, my lord. I have to serve notice prior to 6 months before your lordship under section 106 of the Railways Act. If my lord, I am seeking compensation or refund, my
You
lord.
want to say that Railway Claims Tribunal is not competent to decide such issue, or it has not been vested with the jurisdiction to decide
Legality
issues
and-
of such nature.
This is my submission that I will place, my lord.
Okay, yes. What is your content?
Is it alternative efficacious remedy is there? Railway
What-
Claims Tribunal is there, Lordship.
No, tell me the jurisdiction must be there.
Jurisdiction.
He is
Lordship,
raising,
And this issue was already settled by our High Court, Lordship. T4 judgment is delivered, even yesterday also delivered, Lordship. Exactly same issue, Lordship.
okay, I don't know.
Lordship.
Then it will be easier for me.
Lordship.
Please
Lordship.
hand it over.
Lordship.
If that is the exact issue.
Something may be given or I shall be happy, my lord.
Sure.
Lordship.
Okay, where is the jurisdiction clause of the?
First, kindly come to objects and reason of enactment.
No, which act?
Railway Claims Tribunal Act,
Railway Claims Tribunal Act.
1987.
Nine waited. এখন তো নাই সৰু এক ছেকেণ্ড the other learning council can take the dates in the next week are the remaining matter. Railway Claims Tribunal.
Objects and reason of enactment.
Next week date. All the remaining cases. Madam.
Objects. May I read your lordship? First page. An act to provide for establishment of railway claims tribunal or inquiring in and determining claims against the railway administration for loss, destruction, damage, deterioration, or non-delivery of animals or goods entrusted to it to be carried by railways, or for the refund of fares or freight, or for compensation for death or injury to the passengers occurring as a result of railway accidents, and for the matters connected therewith or incidental thereto. So, my lord, so far as legal.
And inside the act, what is the jurisdiction?
Section 13, my lord, 1(3). Jurisdiction, power, and authority of claims tribunals. The claims tribunal shall exercise on and from the appointment date all such jurisdiction, power, and authority as were exercisable immediately before that day by any civil court or claims commissioner appointed under the provision of the railways relating to the responsibility of railway administration as carriers under chapter so and so of the Railway Act in respect of claims for compensation for loss, destruction, damage, deterioration, or non-delivery of animals or goods entrusted to a railway administration for carriage by railway. Second, my lord, compensation payable under section so and so of the Act or the rules made thereunder thereafter, my lord, in respect of the claims for refund of fares or part thereof, or refund of any freight paid in respect of animals or goods entrusted to a railway administration to be carried by railway.
Okay, Mr. Gogoi, show us your judgment.
Lordship, here we are challenging the legality and validity of penalty, imposition of penalty.
How it has been interpreted, let us.
Mine.
Here লসিপ paragraphs বাজুতে দিলে না
Which paragraph?
paragraph 16 17 my lord may just kindly mark it, then I will paragraphs
16, 17.
16 17 18 19 lordship.
Just a minute. 16, 17.
And 27 28 29 and
16,
30
17, 18.
16 17 18 19 lordship. 27 28 29 and 30 lordship.
27. 20.
29 27 28 29 and 30 lordship. Then I will lordship paragraph 16 lordship. Paragraph 16 lordship.
Mr. Gogoi,
Lordship.
I have some problem. I have meeting.
Lordship.
Because of that one item, everything.
Any day lordship.
Any day next week.
Next week.
You go through it.
My lord.
Get the opportunity to go through it.
70
Note down the number,
7096
WBC 7096 2000. Give him the number.
Lordship,
My lord.
Next week, Tuesday or
Next week.
Thursday
Not this Tuesday. Put
Friday
it on Wednesday.
or Friday, my lord, Wednesday, I have some.
Friday.
Friday.
Repeat নাম কেটে repeat করে দিব। Due to paucity of time. Case must be taken up today. List the case on friends.
Interim order may kindly.
Interim order.
Lordship, my item number 39, earlier order directed the matter to be listed on admission, Your Lordship, since service was completed.
I am
Again, it
not,
came back in
I will not exercise. Take a date in the next week.
Well, I'm small prayer, that item 44, actually, it should be listed for admission.
No, I will not go through. It will be, take a date, give a date.
No, it will.
Give a date, otherwise I have to, I am rushing for that. So I am accommodating you to that extent. If it is admission, we will take up if possible. All the parties are there. Nothing to worry on that count.